Or until we hear anything more. Is it unmuted? I did get oh, echo.
We actually have power supply.
Yes.
You are unmuted.
Oh, that's full of great ideas, Axel. Full of great ideas.
Well, you have to have an engineer.
I know.
And then it's all under control.
Unmuted.
Go.
Has anybody else got a trim? That blue, I'm going to put this on, if they want trim. That is my trainer. They don't want decaf, have a cup of tea.
Go.
Yeah, yes, it's sweet. Sweet, now there's sugar.
We should have just made it.
Jug.
Here we go. That is
Yeah, exactly.
Cool. So we're just unmuted at the moment because
So
Andrew's just run upstairs. Yeah.
Bring it back down.
He's only in the room, he's only on the second floor too.
Oh, is he?
Yeah, he's
Perfect.
down with the policy planner, so.
Sweet. I've got the chat ready to go. So when we're on a break, which will be 12:30. Yeah. So stop it because that made me laugh. Yes. I'll have to. Hi Andrew, how you doing? Good.
Are we gonna have enough room?
Yes, I think we should be, shouldn't we? Yeah. Everybody's quite spiced out, hopefully, with the hearing.
Right.
If not, I'll be running around getting the chairs.
Just give us a yell because we can grab another table.
There's a few streaming in up.
Yeah, I think so. I think most people are streaming in. So that's all good. Perfect. So I printed those up this morning.
Yeah, just for some reason I couldn't print it on the system.
That's all right. No, it's no worries at all. I did it first thing. So yeah, and then underneath that is Ron's printed copy. I haven't distributed them until he does the submission, but it's just for you. And also that's all the signatories that we got as part of the submission, which are pretty. It's like
that came in with the application.
all the submissions. No, it came in with the submissions at the time of submissions. So,
Oh, okay.
yeah, she. I think that she just thought it was supporting documents. Which
Probably just had a list of people who came through the property.
Yeah, I think so. Yeah.
Wow. Yeah.
Yeah, but it has phone numbers, so that's why I don't really need to.
Yeah.
We've got team copy here, so help yourself. And if you need a charger, we just put the charger in the
Yeah,
middle.
I'll try and manage that my laptop, but I might.
I'll be.
Actually, I might use this to hit some of that. Is there a Wi-Fi password I can?
There is, yes. I will get onto that. Yeah. Which one? Yeah, I will.
Public one.
Yeah, because
It's free.
yeah, but I wonder
All right, good morning, everyone. Thanks for your patience. My name is Andrew Henderson. I've been appointed as an independent commissioner by Christchurch City Council to hear the application for the extension of the Giants House in Akaroa. I'll just run through some introductory and procedural things before we hand over to the applicant. First of all, you'll see we have a short lunch break from 12:30 to 1. Depending how we're going for timing, we can make that longer if need be. I know there's a lot of information for people to get through, so in the interest of time, it's always good to try and keep things moving. We'll take a morning tea break around about 11 if there's a good break and evidence at that point. I know it's a long time to sit and listen for those speaking as well, so good to take a break. For those of you unfamiliar with the council building, toilets are back through the door you came through, just to the left. Exits in the event of an emergency will just follow staff direction. Just ask that cell phones be turned down, please. I'm guilty of that myself, having a cell phone go off in a hearing, so to avoid any embarrassing moments would be great. Thank you. Just a reminder too that the proceedings are being live streamed and recorded for the benefit of other submitters who can't be here in person. So if anyone doesn't want to appear on camera when it's your turn to speak, please let us know and we can make arrangements for that. For the benefit of submitters and those who are unfamiliar with the process, the order we follow first is the applicant goes first, followed by with their experts, then followed by submitters who have the chance to speak to their submissions. Following that, there's council officers who have a chance to speak to their reports and address any matters that they wish to comment on, having heard submissions following their reports. And finally, then there's the right of reply for the applicant, which can either be orally on the day or in writing, and we can discuss that as we go, depending on how things unfold. For the benefit, again, of those unfamiliar with the process, we'll ask questions of various people as we go. Sometimes they might be about conditions, sometimes they may be about other matters, but just to note, that doesn't indicate that I've made up my mind. It's purely to explore all possibilities and make sure I understand the issues from both sides of the case. Normal rules of engagement apply. Please respect those who are speaking. Everyone will get their chance at the right time to have their say, and just there's no ability for cross-examination. For those of you familiar with the process, we understand that, but in terms of procedural issues, there are some late submissions. I've had a recommendation from Ms. Cotton that they've accepted, and I have no problem with that. So I'll formally record that now, but I'll also issue a written part as part of the decision coming off as well. And just before we do introductions, are there any procedural issues, council side or anyone else? No? Excellent. All right, well, first of all, let's do some introductions. Ms. Cotton, do you want to introduce yourself?
I'm Rachel Cotton. I'm a senior planner and the resource consent processing officer for this application.
My name is William Field. I'm an urban designer with Christchurch City Council, and previously Josie Martin was working on Josie Schroeder. Sorry, Josie. Yeah, but I have taken that over from Josie Schroeder. So thank you.
Kia ora koutou katoa. My name is Isabel Stout, and I am here on behalf of Council to give evidence regarding environmental noise.
Thank you.
Kia ora koutou katoa. My name is Axel Donald Wilken. I'm here to give transport evidence on behalf of Council.
And that's the only evidence presented to council?
Yep.
Awesome, thank you.
Great. Hi, good morning, everybody. My name is Jared Cleary. I'm solicitor for the applicant.
I'm Demianne Donaldson. I'm a consultant for the applicant.
Good morning, Simon J. Josie's son here in support.
I'm Josie.
And in the background, we have
Dave Cotton, representing the applicant. John Farr, representing the applicant from Royce.
Sure, I assume we have some submitters as well in the room.
I'm Ron Birch. I live in number 76, adjacent to the youth club.
Morning.
Warcraft, neighbour 72.
Yeah, morning.
Anna.
I'm Anna Freed. I'm a friend of Josie's.
Sure. That's Anna submitted. Yep.
And we have some planners who have just submitted.
Sure, no, that's fine. And I'm sure there'll be people coming and going throughout the day, so that's fine. All right, well, Mr. Cleary.
thank you. Just just a preliminary matter. The experts, including Damian, Dave, and John, have all prepared brief summary statements.
Thank you.
Just essentially, but the client, Ms. Martin, hasn't prepared. And so it's certainly up to you to ask any questions you may have of her. So I've got some relatively brief legal submissions. Let's start the introduction. If anybody has any problem hearing me, because I am quite softly spoken as a rule, but just tell me to raise my voice. Okay, but introduction. Fundamentally, what is sought is an upgrade and extension to an existing multiple award-winning visitor facility at Giant's House. Akaroa is undisputedly a town whose economy is heavily reliant on tourism, and in that context, the ongoing contribution made by the Giant's House to Akaroa cannot reasonably be disputed. It's admittedly an invaluable asset. The proposal is intended to enhance the experience of the broad range of visitors who come to enjoy the unique experience that is the Giant's House. At the same time, the proposal is intended to be mindful of its surroundings and potential impact on adjacent neighbours. The case for approving the proposal is set out in the comprehensive expert evidence filed on behalf of the applicants. In essence, what these experts conclude is that the effects associated with the proposal are entirely acceptable and its approval is consistent with the policy framework of the district plan. This conclusion is different to that of the principal author of the Council Section 42A report, but fairly and reasonably, Ms. Cottam acknowledges that there is the potential for most adverse effects to be resolved through acceptable mitigation, thereby reducing any perceived conflict with the relevant provisions of the plan. And sort of prompted by Ms. Cottam's analysis, the applicant has agreed to additional amendments to the application, all of which are intended to further reduce any potential impacts on residential amenity. These amendments include agreement to a limit of patrons per hour and the provision of additional landscaping detail to address matters such as privacy and the visual appearance of the various components of the proposal. These recent amendments must also be considered alongside the amendments proposed in response to submissions from neighbours on the proposal, including setting back the entrance building and an extension of the footpath along Rue Valgarie to provide a pedestrian route to the site. And taken all together, submitted these amendments render the proposal appropriate to its context. Just set out the statutory framework very briefly, Section 104, and this is covered in the Section 42A report, but at 2.2, the matters to have regard to. And a footnote of what that actually means. Genuine attention must be given to each of the matters, but they must not necessarily be accepted. But you must have regard to the potential effects on the environment relevant provisions of the district plan, and that's broader than the objectives and policies, but includes everything else really, and any other matter you consider relevant, reasonably necessary to determine the application. In this case, the related concepts of precedent and plan integrity have been raised in the Section 42A report. But to state the obvious, the relative weight to be given to the 104 considerations is essentially a matter for you, having regard to the totality of the evidence. Section 104 is expressed to be subject to Part 2 of the Act. The applicants accept that recourse to Part 2 is not necessary in the present circumstances. So we agree with Ms. Cottam on that. But that said, in dealing with matters such as the maintenance and enhancement of amenity values, case law remains relevant as to the approach to adopt, and I've discussed those towards the back of the submissions. But I'll just deal first with two alleged effects. I'll deal with these on a preliminary basis, and this is firstly potential trade competition effects, and secondly potential impact on property values. And firstly, in suggesting that the expanded cafe may have a negative effect on other businesses, the Akaroa Ratepayers and Residents Association has raised the spectre of trade competition. Effects of trade competition cannot be considered, particularly so when the issue is raised in such a speculative manner, that is, without any evidence that even remotely suggests the cafe will be disenabling of the well-being of Akaroa's commercial centre. Second, a number of submitters refer to potential impacts on property values, and I'll just refer here to the tram lease case, where I summarise the case law, and I don't need to take you through that. You'll probably read that in your own time.
No, that's fine. I was making note of it.
Yeah. But so in the present case, there's no reason to debar from the settled case law outlined in those paragraphs, particularly as no expert evidence as effects on property value has been provided by submitters. In dealing substantially now with the issue of effects on the environment, I sort of addressed first what is the receiving environment, and the relevant on-site and off-site or receiving environment is suitably described in the application and evidence, including the Section 42A report. The site is zoned residential Banks Peninsula, as indeed are all surrounding properties. This receiving environment is accordingly subject to typical everyday effects associated with residential use, including effects such as noise from a range of sources, including traffic, people, music, and the use of tools and machinery. The evidence and submissions support a conclusion that these everyday effects vary in intensity depending on the time of the year, being at the highest during the peak holiday periods. Of particular relevance, the receiving environment includes all effects associated with the exercise of the consent granted to the Giants House in 2001. And of course, there's also the consent for the interlinking staircase as well. That needs to be factored in. But the 2001, I've paid attention to the 2001 consent. And I say it's a product of a simpler time when consent applications were not subject to the same forensic scrutiny as they are today. And the net result being a degree of uncertainty as to the scale of the operation then approved. And I submit that the consent must be viewed in its entirety and not simply by reference to the actual decision itself. And relevantly, the application includes specific reference to garden visitors in the following terms. So the visits are mainly in spring and summer, individuals do, small groups, occasional bus group visits, etc. And in terms of the parking arrangements, parking is provided top of the driveway where approximately 6 cars can accommodate vans, small and medium buses. Large buses park on the street and people walk up to the drive, but usually the buses are only occasional and are here for a maximum of 3/4 of an hour to an hour. The majority of visitors walk up from the town, apart from the older generation who drive up. The then proposed cafe is described in the 2001 application as being small scale. This being the only physical aspect of the proposal described in such terms. The cafe is simply one component of the Giants House visitor facility for which approval was sought and granted. And it would therefore, in my submission, be a mistake to conclude the 2001 consent is some sort of proof the Giants House activity is or was a small-scale attraction. Overall, it is specifically contemplated by the consent that a range of visitors, individuals and groups will arrive on site by a variety of means, including cars, small and medium buses, and occasionally large buses. The effects associated with these visitors, including those everyday effects that I've mentioned before, such as parking on roads, noise in vehicles, and noise of conversation. In addition, there are visual cues of commercial activity evident by signage and by visitors entering and leaving the site. The conditions attached to the 2000 consent are brief in nature and effect. They do not specify a limit on the number of visitors that may be on site, either on an hourly, daily, weekly, or annual basis, and accordingly cannot be said to have precluded an increase in visitor numbers over time. Nor do the conditions express any limits on the number of vehicles or buses that may park at Ruberg, Calgary, nor do they impose any management plan on those the buses. They do have it's acknowledged that it says the large buses are occasional only, but I've just gone to say that the conditions specify an ability to review the condition of consent, a process which is intended to enable further scrutiny of adverse effects associated with the exercise of the 2001 consent. in the 22 years or more that the consent has been granted or exercised. To Ms Martin's knowledge, the council has not received any complaints regarding the Giant's House. The conditions of the 2001 consent have never been the subject of review to address its ongoing effects, nor has the exercise of the consent been subject to enforcement action of any type or degree. Objectively regarded, therefore, this absence of scrutiny points to the conclusion that the existing activity and its associated effects blend into and do not materially impact on the receiving environment. And acknowledge, of course, there's a clear tension between what is approved and the unprecedented levels of activity at the Giant's House on those occasions when large cruise ships were berthed in Akaroa. As Ms Martin has outlined in her evidence, the likelihood of a repeat of those days is not high, given the establishment of the new facility in Littleton. Even if the levels of tourist activity in Akaroa did reach the same peaks as previous, the limit on the number of patrons, together with appropriate traffic management measures, will avoid any repeat of what was experienced at the Giant's House. Positive effects, they cannot be overlooked in the exercise of an overall judgment under 104. And here, Ms Cottam agrees the proposal has a vast number of positive effects, ranging from contributions, the contributions of the Giant's House to the economic and social well-being of the Akaroa community, and to the support revenues on the operation provide towards the maintenance of Linton. And that, of course, is detailed, the contribution it made towards the maintenance of the heritage building is set out and detailed in Ms Martin's evidence. So approval of the present application will reinforce the Giant's House experience and therefore help secure all of those benefits for the future. In my submission, this is a factor which should be given considerable weight. Adverse effects, scale of acceptability, and that's a preliminary point, is the question of what is a significant adverse effect. And Ms Cottam has made it a decent effort, actually, to actually try and interpret what that actually the word means in terms of an assessment against that particular policy. And it's a policy which refers to supporting the redevelopment and expansion of non-residential activities, provided they do not have a significant adverse effect on the character and amenity of residential zones. The courts have not sought to define what significant means primarily, and this is my suggestion, because what constitutes a significant adverse effect will inevitably depend on context, and therefore will typically be determined by a range of evidential factors, including but not limited to the importance of the resource or the environment in question, the nature of the receiving environment with sensitivity to the change proposed, the degree of influence of the adverse effect beyond the site of the proposed activity, that is, the wider the influence of the activity, the potentially more serious or significant effect, whether the effect is cumulative on the effects of other similar activities in the receiving environment, such that a tipping point is or may be reached by the activity. The nature of the effect in question, including whether it is an everyday or unexpected effect, and its ability or otherwise to be assessed against objective standards or indicators, and then we have noise, traffic, and privacy, or is more subjective in nature, street scene, visual appearance of buildings, and the design merits. And finally, the adequacy of any proposed mitigation, including conditions of consent. So I think in summary, what I'm trying to say is that in determining whether an effect is significant, it's essentially a process that you would go through, because it's difficult to say whether, you use the word severe, which Ms Cottam has, and it's a pretty high threshold, but it might not. Whether it's severe or not ultimately is going to depend on matters such as context. Yeah.
So you'd say it's more complicated by the fact that it's a discretionary activity, because for a non-compliant activity you have the bar of a more than minor effect, which is perhaps easier to quantify, but something could be significant and more than minor and then still not fail the policy threshold.
Absolutely. Just in terms of what the relevant adverse effects, and I think there's general agreement that these include the urban design effects. That's a kind of collective term I'm used, but I mean it encompasses the appearance of the proposed cafe and entrance buildings, noise, privacy, air, transport related effects. Of course, these are all set out in detail in the evidence, so I'm only going to touch on them briefly. But firstly, with the urban design effects, in terms of your approach to assessing these is submitted, that must be informed by the provisions of the district plan. And relevantly, and as a starting point, because the plan contemplates and indeed supports the expansion of existing non-residential activities, it must necessarily, in my submission, be problematic to suggest that the appearance of the cafe and entrance buildings as commercial in nature is inherently an adverse effect. In the same vein, it's equally problematic to assess the expected residential character of a residential zone without acknowledging, again, that the plan specifically contemplates the expansion and upgrade of non-residential activities. Further, the district plan does not prescribe that new or expanded non-residential activities must take place in houses or indeed buildings that look like houses. Fundamentally, therefore, to the extent that commercial appearance could be considered an adverse effect, appearance alone should not be determinative as to either the scale of adverse visual effect or consistency with the character of the surrounding residential environment. Rather, it's submitted that a more nuanced approach is contemplated, one that takes into account all relevant factors. And Mr. Compton-Mohan concludes that the proposed buildings are of an appropriate scale consistent with the dimensions of surrounding properties and sited within existing site topography to minimize visual bulk. And that I don't think that his opinion on that is disputed. Mr. Compton further considers appropriate spacing as provided with neighbouring properties consistent with the existing fabric of development. He also notes, as does Ms. Schroeder, the diversity of building forms, styles, finishes, and colour palettes in the surrounding environment, and concludes that the proposed buildings are not out of place in terms of both the street and the more unique setting of the Giant's House. This latter observation is, of course, relevant in the sense that it would be artificial to exclude the existence of the Giant's House from the expected residential character of the residential environment. And the above aside, Mr. Compton's evidence includes an updated landscape plan which illustrates the woodland nature of the proposed garden setting between the cafe and the entrance building. This will, in Mr. Compton's view, further improve the attractiveness of the street, given the garden will be largely screened with greenery. The Commissioner will note Mr. Compton-Mohan's updated landscape plan seeks to address the various matters raised in Mr. Field's urban design assessment. At this point, is not knowing whether there is any or there are any remaining differences of opinion between these experts, and to the extent any differences may remain, there should, it's suggested, be confined to matters of detail on the mitigation. And I'm going to suggest, Commissioner, that Mr. Field and Mr. Compton-Mohan can sit down and have a discussion, and so we can actually have some clarity as to whether or not there are any differences of opinion. As a further point of detail, and in response to Ms. Cotton's comment on signage, it's proposed that this be limited to the same scale as approved in the 2001 consent. And so therefore, commercial signage of that scale is essentially already part of the receiving environment. Taking the above considerations together, it's submitted that the proposal, including the comprehensive landscaping, reflects the character and context of the surrounding residential environment in terms of scale, diversity of design, and patterns of development. Accordingly, it's submitted the visual appearance of the buildings as mitigated should not be considered significantly adverse. And fundamentally, of course, as we all know, it's like sort of design is fairly subjective. Yeah. One person could consider the buildings extremely attractive, and the other could reach a completely different opinion.
No, I understood. I've got a question, so Mr. Comment on that.
Yeah.
That issue.
Just a noise, dealing with that briefly. It's addressed in Mr. Farron's evidence. He's of the opinion that the proposal will achieve the relevant noise limits in the district plan, particularly as a consequence of the agreement to reduce the maximum number of patrons on site to 80 per hour. As such, if a proposal achieves the noise levels in the district plan, then inherently the noise generated must be reasonable. And I refer to just a brief paragraph from Justice Thompson in Poll on this thing, and he said, as noise sourced from the restaurant building could be made to comply with the district plan rule, the effects of noise would not be adverse in that the rule is an expression of what the community regards as acceptable. As a consequence of submitted, there's no basis to conclude, as Ms. Cotton has, that the adverse effects of noise are significant and unacceptable. And in saying that, I acknowledge, of course, that her opinion predates agreement to reduce the maximum number of visitors on site. Yeah, and that was the recommendation of Ms. Stark, of course. Privacy matters addressed in the planning and urban design evidence. The district plan at submit does not contain any indication that privacy is a component of amenity which must be protected or preserved at all costs. In other words, the district plan does not seek to avoid impacts on privacy. Instead, the plan refers to a range of mitigated measures intended to address potential privacy effects, including setbacks from internal boundaries and the use of fencing and landscaping. And the proposal before you incorporates just such measures, including extensive boundary landscaping in addition to the existing fencing. And it also incorporates appropriate separation distances. And that's separation distances from the statutes from the boundary. The pathway will be separated from the boundaries. The buildings will be separated from the boundaries. The buildings, the cafe building will be, I think, on Miss Donaldson evidence, perhaps something in the order of 50 metres away from the north-facing living areas of the 72 and 76. And at paragraph 332, the Commissioner will note the existing and proposed level of landscaping on the internal boundaries and the level of screening this will provide in conjunction with fencing. The Commissioner will also note the key living areas, say, including outdoor living spaces of adjacent properties to the north of the proposed site. They have a north-facing outlook. As such, the extent of impact on privacy by way of overlooking into these key areas will be minimal. Similarly, the extent to which people moving around the Giant's House will be visible to the owners of these properties is likely to be limited and not adverse. There is a residual issue regarding potential privacy impact of people congregating outside the Giant's House. As submitted, I changed the order of my submissions, but I would say that a real-world approach to assessing potential future effects would conclude that this is only likely to be an issue, if at all, during peak periods, and even then for brief periods of time between the hours of operation. Further, to the extent it may be an issue, one has to factor in the likely time people will be outside on the street, together with matters such as the distance between residents' outdoor living spaces and the street, and measures already taken by residents to provide for their own privacy. But, for example, landscaping. A good example of that would probably be number 76, where you have extensive landscaping along the frontage. And number 72, you've got a degree of setback from the from memory. You've got a degree of setback from the street as well. And to the extent maybe issue. Oh no, sorry, I finished that. So I move on to transport effects. And on this particular matter, there's a consensus of expert opinion, the effects are minor and therefore acceptable. As noted above, an issue outstanding at the time of release of the Section 42A report was the need otherwise for a transport management plan, and this is no longer an issue given the limitation of numbers to a maximum of 80 per hour. And just finally on effects, I'll just talk about the scale of effects, and it's appreciated that Ms. Cottam has approached the task of assessing effects on the basis the activity could generate the maximum number of visitors stated in the evidence regardless of the time of year. Fundamentally, the thresholds are included to provide certainty as to the maximum numbers and to provide reassurance that a repeat of the level of movements associated with the cruise ships simply cannot reoccur. The agreement to a maximum of 80 per hour also stems from the suggestion in the Section 42A report. This was an appropriate limit, one which the Council's experts were more comfortable with. Beyond that, a real-world approach to the worst-case scenario approach of the reporting officer would readily conclude that the maximum allowed visit numbers are very unlikely to be achieved except in the peak periods referred by Ms. Martin in their evidence. And for the majority of the year, it is more likely than not that the Giant House operation will simply continue to tick over in the same low-key manner as it has done for the last 2 decades or more. And so in terms of conclusion on effects, as noted at the outset, the amendments to the application, further evidence presented, are responses to the suggestions in the Section 42A report as to further mitigation of effects. And having regard to these amendments is the applicant's position that all effects are appropriately addressed and therefore cannot realistically be considered as significantly adverse when objectively assessed. All experts agree that conditions are appropriate to ensure effects are managed, the fundamental presumption being, as a matter of law, that conditions, such as the maximum limit of numbers, will be complied with by the consent holder. In terms of the objectives and policies, assessment of the proposal's consistency with the objectives and policies is, of course, informed by the assessment of effects, particularly the case given the enabling approach towards redevelopment and expansion of existing non-residential activities, provided this does not result in significant adverse effects on the character and amenity of residential zones. And of course, to state the obvious, all relevant objectives and policies must be considered. And in that respect, with the reduction in maximum numbers proposed, there should be no dispute between the experts that the noise objectives and policies of Chapter 6 can be achieved. And given predicted compliance with the noise limits, that's a conclusion which can readily be reached. Similarly, there does not appear to be any dispute with respect to the objectives and policies relevant to transport earthworks in natural and cultural heritage. It being accepted that there's a strategic or operational need for the activity to locate in the zone, we are left essentially with analysis of the proposal against policy 14263 and the urban design focused policy 14.2.4.1 as set out. This is set out on page 3 of 23 of the Section 42A report. And notably, the urban design related evidence on the Council's behalf does not point to a level of effects that could be considered as significantly adverse, instead concluding that in the absence of suggested further mitigation, the effects within his sphere of expertise were moderate to high. Further mitigation in the form of additional detailed landscaping has now been provided, such that intuitively, Mr. Field's conclusion as to the level of effects must be that they are reduced. The level of effects is reduced. It is further submitted that all agreed amendments to the proposal are aimed at ensuring no significant or unacceptable adverse effects will occur above and beyond those that already form part of the receiving environment. That being the case, the applicant's position is that the proposal does not conflict with the district plan objectives and policies, including those within the residential chapter. That's Ms. Donaldson's overall conclusion in her detailed planning evidence. dealing sort of briefly with the issues with precedent and integrity. Again, I've set out what I consider as a very good summary of the law on this issue. Do you want to read through that, no, Commissioner?
I'll read that later.
Yeah.
Is it possible to read a copy of the whole case, just to read it in the context?
I
I'll just read it. I can probably find it online.
Hamilton East case, yep, absolutely, because obviously this refers to a number of, it includes a summary of the case law to date on that. Yep, I'm happy to supply that.
Yeah, I'm happy with that one.
The applicant's position on the effects of the proposal and its consistency or otherwise with the objectives and policy of the district plan leads to a conclusion no weight should be given to issues of precedent and integrity. And in short, the experts conclude there is no irreconcilable clash, which is actually the term used in that case, with important objectives and policy of the district plan. It's further noted that there's no evidence to support the proposition that granting approval will lead to the possibility of further materially indistinguishable applications arising. And I think when I make that submission, it's consistent with Ms. Cotham's thinking. So while precedent and integrity can sometimes mean different things, a finding of fact on the scale of effects associated with an individual, a unique application is unlikely to have any meaningful influence on the community's confidence in the integrity of the district plan. And just briefly on conditions, with the input from other technical experts, Ms. Donald has suggested a number of refinements to the conditions proposed by the reporting officer. Most of these proposed amendments are self-explanatory, but they're intended to provide more certainty as to matters such as the scale of signage and to improve the overall workability of the condition. Conditions of the scale of the activity have been amended to remove the prescriptive approach suggested and to essentially put the onus on the consent holder to develop and establish a system that ensures the maximum patronage limits will be met. And to provide a further certainty this will be effective, Ms. Donaldson has included a review condition specifically focused on the booking and monitoring system to be established. And the other side, to the extent that the proposed set of conditions are a work in progress, further input is welcomed by the applicant. And finally, and just briefly with part 2 of the Act, the applicants agree with the reporting officer no further assessment is against part 2 is necessary. That said, the courts have discussed the approach towards an assessment against the requirement to have particular regard to the maintenance and enhancement of amenity values under Section 7C of the Act. And of course, as the Commissioner will know, it's common practice to lump in Section 7F, which is the maintenance and enhancement of the quality of the environment at the same time. And so I've summarised some of the court's thinking on these issues, and of course it's relevant, particularly relevant here because we're dealing with the issue of what are the effects on the amenity. And so the principles derived from the court's thinking include, while Section 7C refers to maintenance and enhancement of amenity values, High Court and Shell New Zealand held that the provision does not require a proposal to both maintain and enhance amenity. And Justice Ten noted that the Act contemplates applications for consent that not only do not enhance an amenity, but also do not maintain it. And just saying the Court of Appeal in that case agreed. And then at Port Otago and Dunedin, the court held that the requirement of particular regard to maintenance and amenity does not prevent there being some detraction from amenity. And the Environment Court held that the requirement to maintain allows a consent authority to protect rather than preserve or enhance. Protect means to keep safe from harm or injury and does not require prevention or prohibition. In a making assessment of amenity values, the High Court in Aldamas found that the Environment Court must apply the law objectively. Similarly, in Schofield, the court found that whilst the assessment of amenity values must, in our view, start with an understanding of the subjective, it must be able to be tested objectively. in Hoot, the court following Schofield noted that as people can have competing amenity values, the district plan provisions add an important objective lens. And more recently, in Yolhurst, Corey, the court set out a proposal on assessing amenity values as including identification of the values of people and communities, including whether the district plan identifies any valued attributes or characteristics for the relevant zone. And the next step was to determine whether or not amenity values are reasonably held. Statement in that regard, we expect the experts to objectively test the basis of values that are derived from the environment. This is necessary because residents' views on their existing amenity is subjective and influenced by personal feelings or opinion, including the strength of their attachment to this place. As with Damas and Schofield cases, therefore, it is explicit that while an appreciation of amenity can start with an expression of relevant tangible or intangible values through public submissions, the impact of a particular proposal on such values must be assessed objectively. This is particularly the case where there are competing views from submitters as to the merits of the proposal and the benefits and virtues of the giant house. In the applicant's case is that when looked at objectively, the amenity values of the received environment are maintained to the extent and degree anticipated by the district plan. And when I say that, I just as a reminder to the Commissioner that the district plan does, and that's 7.7, does specifically contemplate that the approval of applications to extend existing non-residential activities can lead to adverse effects, i.e. some diminution or reduction of amenity values. The focus comes back to whether or not these effects can objectively be regarded as significantly adverse, and the evidence for the applicants is that this is not the case. Thank you.
I do have a few questions.
Good.
As we go, so just be with me for a minute. That's all right. So I suppose, and if you consider what would happen if this consent didn't proceed.
Mm-hmm.
I can't hear you. Sorry. If this consent didn't proceed, then the applicant will continue under the 2001 consent. And as you've noted, that has some uncertainty as to scale and as to the extent of activities consented. So there would still be vehicles up and down the street, there'd still be buses, there'd still be people visiting the site.
Yes.
So that's I guess not putting words in their mouth, but that's part of your view of the existing environment and why it's important that we're not dealing with a yes or no to the total activity. We're dealing with an extension to what's already there and what is consented.
Yeah.
Okay. In relation,
you must have been keen to those issues of the uncertainty of numbers, etc. We're actually providing a framework.
That was my.
I'm sorry, but I'm struggling.
You're still struggling to hear?
And I've got my hearing aids.
So what I'm saying is that actually, sort of what this consent does, it provides that certainty as to the actually numbers, the limits on the number of people.
That was my next question. That in advancing the application as it is now, it wraps some limits and parameters around what's already occurring. Granted, there will be some activity on the additional piece of land.
Yes.
But, and I guess this comes back to your evidence that this isn't necessarily an expansion. It's allowing the activity to spill over into another piece of property that people can visit, but in itself, it's not going to necessarily attract more people to the site.
Not necessarily. It's a physical expansion, so obviously, because it does extend into 74. But nobody can say with any certainty whether or not the numbers of patrons will expand beyond what we are.
So if that's the case, if there's no...
Sorry, there's no opportunity for cross-examination. Sorry. Happy for you to note your questions down and ask them later on. Coming back to the 2001 consent, then it's not being surrendered, is it? It's going to sit in behind
What I would envisage would happen, because as you will have noted from Ms. Martin's evidence that what the stage approach towards the development is proposed. So firstly you have the cafe, and then you will have the path. Then there will be the planting of all the trees, the woodland garden, and the pathway will be constructed, and then the entrance building. But until the time that the entrance building is completed, so that people will access the site via the existing driveway. But when at the time, this is what I would envisage, at the time when the entrance building is complete and operational, then that would overtake the 2001 consent.
Yeah. Okay. The question again on the 2001 consent. That consent included the provision for the car parking at the top of the driveway.
Yeah. There are six.
Yeah.
Six car parks.
That's to address mobility issues or the larger vehicles for people who can't. It's not so much the issue that it's for. I was concerned that concerned about whether there be an issue of either non-compliance or whether there's a breach of that consent if those car parks have been removed, and whether that original consent needed to be varied. I hadn't thought too much about it. Yeah. It just struck me that in one of the statements of evidence noted those parks eventually would not be used anymore.
Yeah.
And if the underlying consent wasn't being surrendered or consumed in this one, then it's a technical non-compliance, I guess.
Yeah, I think we can address that issue by means of condition.
Yeah, and even some thoughts around, and I noted too, Plan Change 5 removed the need for car parking requirements.
Yeah.
So that would also be relevant.
It would be. But yeah.
Yes, and it's not a big issue. It's just struck me as reading through.
Yeah, I'm just trying to think what the effects associated with that. As I understand it, and Josie will confirm, the main benefit of the car parks at the top would be for people with sort of much more limited mobility. So that, noting, of course, that the site isn't and could never be sort of wheelchair friendly.
Some questions around how you would enforce and monitor a cap on visitors, but we can perhaps discuss that with the relevant experts.
Yep.
Yeah, that's fine.
I mean, we would envisage, but it's not something that I don't think that the full detail needs to be provided for at this point in time. But what we would envisage is like kind of, and I'm not an IT expert, of course, but like an off-the-shelf system that could actually manage the bookings. You know? But as Ms. Martin has said in her evidence, in terms of the walk-up visitors, which are obviously contemplated by the 2001 consent, are fundamental sort of.
Totally, yeah, I've got that, and I guess that's the tension, isn't it, between trying to manage numbers, but also providing for those who may come on a whim or unannounced.
But ultimately, the onus will be on the applicant to ensure, or the consent holder to ensure that those maximum limits cannot be breached.
You made a comment in 318 just about the expected residential character. And this is talking about the urban design and objectives and policies. And again, this goes to, I think, your point about the importance of the evidence, because the plan fundamentally doesn't define the expected amenity in each residential zone. It's very much a high-level document that says each zone has its own amenity.
Yeah,
and you should assess applications within that context.
Yeah, it is a very high level, because ultimately, for example, for the residential Banks Peninsula zone, you have that table which talks about the expected character of the zone, and it's like perhaps like 1 or 2 paragraphs. So it's extremely high level, and it doesn't necessarily recognise that within the zones there are sort of gradations of character, different, a wide variety of different characters. And for example, in in Akaroa, I'm pretty sure the evidence talks about the historic heritage character area, which can be considered distinct because it's objectively regarded as a more important resource than the balance of the residential Banks Peninsula zone.
Mm.
And you know, when I talk about the range of factors that need to be considered, that to me would be a relevant factor.
Mm.
Yeah.
Just a very brief question around covered people concerns around congregating on the street.
Yep.
And it's probably no need to state it, but the street is a public place, and in any event, there's nothing to stop any person or anyone congregating outside any property or using the street for.
Just walking.
It's just walking.
Walking. Yeah. It's not. It wouldn't typically, in my view, be considered. It's the first time I've sort of confronted that issue in terms of it being in effect, shall we say?
Mm. Yeah, I've normally heard it come up in terms of concerns around antisocial activity or issues of disorder, but that's more confined to activities that happen at night time as opposed to during the day.
And given the demographic of the people who go to the giant class, I suggest that that's
not likely
to be an issue. Yeah. I mean, clearly there. I mean, sort of the privacy of sort of people sort of visiting the site and sort of potentially interacting with the neighbours while they're on the site. Quite clearly, that is an issue that needs to be considered,
and that can be addressed in part, at least through design and landscape planting, to direct people away from those areas,
as is contemplated by the discipline.
And then finally, I think just a comment on the precedent and integrity. My understanding has always been that for precedent, at least, if for someone to claim a precedent, they would have to present an application themselves that is very, very similar in character and scale, and even that this application is presenting. So that's pretty unlikely.
I would
think in terms of
extremely unlikely. I mean, I acknowledge, of course, that Mr. Cotton doesn't think that for that very same reason, sort of was concluded that there won't be precedent.
And similarly, for in terms of plan integrity, the plan contemplates non-residential activities in residential zones, and so any activity that's granted, having gone through the process of considering the evidence and the character of the environment, you couldn't say that's a plan integrity issue. That's just the process working as it should.
Thank you.
And just one last question, I think, in this relation into noise, and we can perhaps come back to this when we hear from Mr. Farron. Just the comment that the district plan exempts road noise or noise within the transport zone is exempt from the rules. So it's not treated as a rule breach, but you have to consider the effects. So
I think he does, doesn't he?
He does cover this. Yeah. So it may be I was just more. Question is more around just perhaps process if noise from the road isn't treated as a rule breach, but it's determined that it's adverse, then it comes down to a question of, again, significance and whether conditions are sufficient to mitigate that potential noise, bearing in mind that it's a public place that traffic uses the road.
I characterise that as an everyday effect, the effect of traffic noise. It's something that, as a community, people living in residential zones, you're accustomed to that every day.
And so then the question is, what is the effect of, what is the degree of effect generated by traffic that's additional as a result of this application, and whether that can be covered by conditions.
As I understand, for example, in terms of
the management plan for the buses, their conditions regarding idling time, etc. And I noted in one of the submissions too, one of the comments from one of the bus operators, who said they effectively manage the majority of trips from bus companies anyway. So there is an element of control that can be addressed through that. Thank you. That's all the questions I had at this point.
Thank you, Commissioner. As I said, I haven't asked Josie to provide a summary, so it's really just if we have any questions of it. I think this is probably Josie's first and probably last year. Probably last year. So maybe a degree of apprehension.
Yeah, no, they're always a fairly daunting.
Yeah.
Confronted by a number of people in suits and people in rooms.
No. Absolutely. So well.
All right, thank you.
We'll have Mr. Farron after.
Sure. Well, I have read your statement. Before I ask any questions, is there anything in particular you wanted to add or highlight?
Yes, just a couple of things noted down. When you were talking about the cafe taking business from other businesses, I certainly don't want to do that. But the Giant's House brings more people to Akaroa from which the businesses benefit. And I think that probably overrides any adverse effect. And our cafe is only for our garden visitors. It's a service in the garden. I mean, it's not usually super busy or anything. It's a service in the garden that adds a very nice ambience to people's visit. Keep them proportion. Actually, I think you're talking about people congregating on the road. I think they'll actually be coming into the entrance house, because the entrance house will be interesting inside, and there'll be information for them to read. We give everyone an information sheet now, but that would be a nice time to sit down and read it before they come in. So I really don't think they never have congregated on the street, and I don't see that they would be with the new entrance house. Why would you do that when you could come in and see something interesting? Parking at the top of the drive, actually, you'd only fit 3 cars, my garage, which means if there's 3 cars, I couldn't get out of my garage, and under the gabion wall. Very often, not always, but mostly staff park under the gabion wall, occasionally at the top of the drive. But, again, to put it in proportion, it's very occasionally, probably once every 2 weeks, maybe less, that we'll have someone in a wheelchair or someone with hips and knees that come, or older people. That, and we certainly open the gates for them to park at the top. But as I say, it's probably once a fortnight we might have a car up there. It's not like every day loads of people coming up. Most people manage the drive, but struggle. And that's the whole point, is this new development is my driveway has been a showstopper for quite a lot of people. And the whole point is to try and provide a more gentle access. That has been the primary focus of this consent we'd go. So that's really all.
I didn't actually have too many questions. Actually, your statement was really very clear and very helpful. But just going back to that really busy time where there were lots of cruise ships coming to town, did you ever have a day where you felt there were too many people on the site?
Occasionally, yes.
There were some, yeah.
Yep.
Okay.
Only when there were like 2 big cruise ships. I mean, you know, I didn't know what the effect of the cruise ships coming to Akaroa was going to be. You know, we just rolled. I mean, we couldn't predict that because things had just been jogging along, and then all of a sudden 2 triple cruise ships come into Akaroa, and of course it wasn't a traffic problem because they didn't have cars. You know, they were walked up, so did people walking. It was nice, but probably on the odd occasion, I think, yeah, I'm not liking this, you know, because, and I mean, I actually don't want that either because I think it detracts from everyone's enjoyment. You know, I mean, as it is, the garden is set up like garden rooms, and people disperse. I mean, they're in the cafe, they're in the music area, they're in that little other area under the bonbon. They're in the gallery, they're sitting up on the throne. I mean, sometimes there can be quite a lot of people in the garden, but you wouldn't actually know because they're all, sometimes they're in that Place des Amis at the top of the drive, and they're all spread out all over the place. So, and in actual fact, you know, 80 people, we've based all these figures on just our existing operation. But we actually haven't quite mentioned that the property will be twice the size. And so 40 people up and 40 people down is not at all in any way crowded. And no, because even at the bottom, because of the zigzag path, and there will be the odd seat because older people do need to sit down on there. I mean, I'm on a hill. We're trying the very best we can to make it as the access as gentle as possible, but older people need to take a breather and have a seat. So there'll be the odd seats on their way up. But the main event will always be at the top. The top has got quite a lot going on. There won't be so much going on. There'll be more garden area in that at 74. And as fast as we can get the screening in, it'll be going in.
Thank you. So would you have a feel for how long people would normally stay on site as an average?
It is completely variable. The odd person, not many, they'll come at opening hours and they'll stay till closing hours. Other ones come in at, like, now we're closing at 3 o'clock. Yesterday, people came in at 2:45. They were happy just because that was the only time they were in Akaroa. And so they were there 20 minutes, quarter of an hour. So only a quick walk round. It's that variable. Yeah. Most, I would say, an average. I mean, we're talking about the top place. An average of an hour and a half. But when it'll take them a little bit longer when we've got the bottom. So it'd probably be, say, probably an hour and a half. Maybe. Depends if they decide to have a nice Devonshire tea and they'll get that.
Save it longer.
Could be sooner.
I think something that's been addressed in the application, perhaps not a focus, is the importance of the overall operation and contributing to Linton and keeping the house going. And I think that's possibly a tension that many people have with they own an historic building that's got a certain classification. The expectation of the state to maintain that is probably quite high.
It is.
But they don't generate funds by themselves. So it's fair to say then that the expansion of this would contribute to the
totally.
ongoing
I mean,
operation costs of
I think
the house.
Jared, we got a quote to paint the house, 82,000. I've just done 2 leaks on the roof, and the builder tells me the back part of the roof's been replaced with the earthquake repairs, but the front, he said, it's coming up. Oh dear, please don't tell me that. I don't want to hear that at the moment, but that is a reality. That will have to be done. The gutters actually need realigning. Had the bottom boards under the veranda fixed. I mean, it's just an ongoing cost, and you can't maintain these lovely old houses if you haven't got an income to be able to do that.
Yeah.
So it's quite important that we have a viable business, otherwise we can't maintain the house. Well, and it was the first bank manager's house. I mean, it's a notable historic house in Tackle. Probably the grand old lady.
It's just escaped my mind for a minute. I think that, oh, this was nice. Mr. Cleary mentioned that there's been no complaints. I sort of confirm that with you, that you're not aware of any complaints in terms of what you've been doing there over the last 20 odd years.
No.
No, I think that was all the questions I had. Thank you. It's as I said, the statement was very clear and helpful. To understand what's proposed, so that's great. Thank you. Thanks very much.
Do you have a summary statement?
Get benefit of 2 Northern Irish accents in one day. It's all planned for zero domination.
Oh, give on, mate.
I'll believe you if you will.
There might be.
Yeah, I know.
Here. Oh, I am happy to read that out.
The evidence.
Yeah.
Oh, the evidence has all been pre-read, hasn't it?
So I should have said that I have pre-read everything.
Yeah.
All right.
Yeah. So that just makes these back in the day, everybody would have to read everything out, which meant hearings took a very long time. It's all pre-read by decision makers.
Sorry, give me just to read through that.
Certainly, that's fine.
Great, thank you. So my evidence describes my assessment of both the existing and likely future noise emissions associated with the Giants House. I measured noise levels from existing operations on a relatively busy day during the summer school holidays in January 2023. There were 80 visitors during the day, including a coach party of 26. Current noise emissions comfortably comply with the district plan permitted activity noise limit of 50 decibels for the zone. I estimate that noise from patrons circulating in outdoor areas was in the low 40s decibels. Even with the proposed increase of maximum patron numbers to 80 per hour, noise emissions will remain below the 50 decibel permitted activity standard. Vehicle noise on public roads is exempt from assessment against the district plan noise limits. However, I have assessed noise from both the projected numbers of cars and buses and consider that both noise sources will operate below appropriate criteria for the protection of residential amenity, and noise effects will be acceptable. I support the condition requiring a coach booking system that limits the numbers of coaches, the frequency they visit site, and engine idling times. I confirm that noise emissions from the proposed cafe will also comply with the applicable 50 decibel permitted activity noise limit, even with the windows open for ventilation. During my noise measurements, amplified music from outdoor speakers was audible at some of the residential measurement locations. In my opinion, this is not acceptable on an ongoing basis, and I support a condition that essentially ensures that music is inaudible off-site. I have reviewed the evidence of Council's noise peer reviewer, Ms. Isabel Stout. To address some of Ms. Stout's comments, I've provided further information on cafe, vehicle, and patron noise in my evidence. My evidence also addresses several issues raised by submitters relating to patron conversation, music, maintenance, construction, buses, lifts, and effects on wildlife. To ensure that potential adverse noise effects are acceptable, I support the implementation of several conditions of consent that control noise generation. Just this is section 6 of my evidence.
Few questions, so just around first of all, the cafe, and I understand that your view on the assessment, and it's largely because in the main the seating is indoors, and although there's windows, they'll effectively act as a barrier for noise. Presumably too that at the boundary that means noise will be less because of the distance. Does elevation factor in that as well?
Elevation does factor into it, so I've got a larger drawing, so it's just to perhaps for everyone's benefit, just to explain that the dwelling is a the building is a two-story building, but it's only the upper floor that houses the cafe component, and that's the bit that's facing north towards the residential boundary along Rue Valkyrie. But there are only two small windows in that facade, and that's why I'm saying that even if it was busy inside with a noise level of around 80 decibels, that the noise breakout through those open windows, even with the elevation and the direct line of sight to the boundary adjacent, we're still able to comply with the district plan limits.
And in terms of, there's been a lot of comment about scale of activity. It's a small residentially sized building. So that wouldn't accommodate, even if it was busy, then you wouldn't see that as accommodating a significant number of people that would generate significant noise.
Yes, I'm not even sure what the capacity of the building is, but it's got a relatively small footprint in it, so there wouldn't be that many patron numbers in there.
Yeah. Well, it's not huge. There was, I think it's a suggestion in either the Section 42A report or the proposed conditions that the existing outdoor seating area used for the cafe be stopped and that not be used. Given its location in the site, do you see that as adding any benefit to stop people sitting outside or any need from a noise perspective?
The existing outdoor area?
Yeah.
Yeah, I think that's my assessment includes noise from that existing outdoor area. That was occupied when I was on site when I was doing those measurements.
Okay.
And so my statements about compliance apply to the outdoor area as well.
Okay. So you'd see no need to preclude that from?
No, I don't. Absolutely not.
I think more noise a bit muffled from the new building.
Yeah, I was actually going to suggest that given where it is, you've got plantings and sculpture around part of the sides, and then it faces towards the house itself. So
absolutely right.
In combination with the distance from the boundaries, that existing area isn't going to be an issue. And
no, and certainly the new building will essentially act as a noise barrier to those two areas.
You made the point when you were on site. It was some 80 odd people throughout the day.
Yes.
So whether that you may say that was relatively busy, perhaps, or sort of an average day. But and I think just confirming, you made the point that following on from what Ms. Martin said, the site is effectively going to double in size. You'll have the same number of people, but more dispersed.
Yes.
And so then that also adds to the fact that there's no single point of noise that's going to be adverse. There'll be a number of pockets of people talking and wandering around and making.
Yeah, I think you're absolutely right. So that essentially the capacity for the site to handle extra noise increases, if you like, because certainly that was my observation, that the people, when they were on site, they were dispersed in smaller groups throughout the garden area. And if the garden area is bigger, therefore the capacity is essentially much larger.
So then if we were looking at a situation where it was at capacity and then we were 80 people on the site, then again that additional site area, having 80 people dispersed, you'd expect the same outcome.
Correct, yes, yes.
So it's going to ask a question, but it would be outside of you. It's a little bit unfair. Noise from wildlife, I think, was an interesting one. The number of submissions concerned about the effects of noise on wildlife. This is fundamentally a residential zone, and so there would be a range of residential activities and all the different noises that accommodate that. So, in your experience, and I understand, I know you're not a wildlife expert, but in your experience, that level of noise would tend to potentially discourage a number of animals or birds from those areas. I mean, it's probably a bit of a
I don't think so. Certainly, even on the day that I conducted the measurements, there were native birds in the trees immediately adjacent to the site. There was Keraroo and so on there, and so the noise profile of the site won't change significantly from what I observed. So I don't see any effect on it. There doesn't appear to be any observable effect.
And we're only talking I think, between the hours of 10 and 5 during the day anyway. We're not talking about hours of activity or operation outside of that.
So yeah, in my experience, bird life and other animals they habituate to noise very easily.
Thank you. I hadn't made any other notes, so there was nothing else I wanted to check with you. I think you had the conditions talk about obviously preventing the buses from idling, which can be a source of annoyance for people.
Yes, yeah.
So assuming then that conditions imposed and it's adhered to, that would, and again noting the buses are on the road anyway, so that noise is exempt, but it would be a positive measure to impose that.
I think that has the potential for a significant effect if those bus noise effects weren't controlled. So it both support the limiting the number of buses coming to site, and I also support that proposed condition to limit the idling time for engines. I think they're both important requirements.
In relation to construction noise, it's a residential zone. But there'd be nothing different between the construction noise associated with the proposed cafe building or the entrance building that's different to construction of a standard residential building, given the scale?
It says exactly the same, similar
Exactly.
techniques I imagine will be used.
Yeah.
So on, yes.
How, in your experience, how effective or how much of a contribution does boundary plantings in the main contribute towards reduction of noise?
They don't contribute to reduction. What I quite often say to people is people will tell me that they perceive the noise as being less, but I can't actually measure the difference in noise level.
Okay.
So I think there's definitely a benefit there, but not one that I can objectively measure.
Yep. Thank you very much. It's very helpful.
Lovely. Thank you.
Mr. Smith, 5 to 11 if you want to.
Well, maybe that's probably a good time to stop for a break. We should be
Absolutely.
checking reasonably well in terms of time. So
Yeah.
Yes, fine.
Brief summary.
Sure. Well, shall we take a break now and come back at 11:15?
Yep.
If that works.
That's good.
Yep.
All right.
Thank you.
Thank you, sir.
Yeah, just told him. I've messaged him now. Yeah.
You could certainly do with a coffee. I go downstairs for a proper coffee.
Hello.
I am concerned about getting to when I'm sort of coming off my head. It's not.
That's what I was wondering.
Suspect we can also be done through.
I
we will
Mum's roads.
we'll carry on. Back to you.
Right, so it's Mr. Smith who has the summary. Significant.
Right, Mr. Smith, thank you.
Thank you. Are you happy to read my summary statement?
Yeah, I've read you a larger one. Just kicking off again. Yeah, happy to read the summary. Thank you.
Great, thank you. I've prepared an integrated transportation assessment to assess the potential transportation-related effects of the proposed Giants House expansion. This included a trip generation assessment of the expected traffic generated by the proposal, which demonstrated that the additional traffic is well within the capacity of the road corridor and is not anticipated to result in any safety or efficiency issues. My assessment considers the Giants House visitor data from 2018-2019, when cruise ships were frequently visiting Akaroa, and a more recent 2021 survey, which demonstrates that current and anticipated activity levels are modest, both in terms of the average number and maximum number of visitors per hour and per day. I consider that these sit comfortably below the proposed maximum of 80 visitors per hour, which is included in the conditions set. I understand from correspondence with Council that submitters have raised concerns relating to parking availability for local residents and the loss of parking related to the proposed mobility park outside 76 Rue Balgary, noting that 76 and 78 Rue Balgary do not have off-street parking. I've prepared a drawing showing average and maximum parking demand over an aerial photograph as attachment 1. This shows the location of the coach parking, the proposed mobility park, extent of no stopping and parking areas, as well as the available parking locations for cars in proximity of the Giants House. I have calculated that there are 22 car parks within 60 metres of the application site, which is a comfortable 1-minute walk. And the average or typical parking demand and maximum or peak parking demand over summer months based on the proposed maximum of 80 visitors on site is 4 and 13 vehicles respectively. The parked vehicles are colour-coded to demonstrate the likely extent of parking occupied by visitors to the Giants House. And I've concluded that there remains ample on-street parking for residents and visitors for other properties in the vicinity. Of note, the mobility park outside 76 Rue Balgary should be located as close to 74 Rue Balgary as possible and leave space for 5 vehicles to park outside 76 and 78 Rue Balgary. By my calculations, even under the maximum parking scenario, there is residual parking in the vicinity for residents and visitors to other neighbouring properties, and note that based on the 2021 survey results, the maximum scenario is anticipated to only occur just under 1% of the time that the Giants House is operating. Based on the current summer operating hours of 11 to 4 p.m, this corresponds to only 16 occasions per annum. Mr. Downard Wilker and I have agreed on a design for Rue Balgary, which delivers substantial improvements to the local network, including the installation of a footpath on the north side of the road opposite 74 Rue Balgary to connect the existing footpath designed to an appropriate standard for the environment. Wheel stops, signage and road markings as shown to improve the safety and reachability of the footpath. A bus stop to meet council standards and corresponding signage directly outside 74 Rue Balgary. No stopping at all time lines, commonly seen as yellow dashed lines, on the west side of Rue Cachalot and on sections of Rue Balgary to assist coach turning manoeuvres and further improve safety on the narrower sections of Rue Balgary. And an adjacent on-street mobility park to improve access for visitors with mobility impairments. The footpath and associated improvements will be an asset for the neighbours and wider community to enjoy, and in my view, are more than appropriate based on the scale and nature of the effects associated with the giant house activity. The delivery of these improvements are included among the set of conditions intended to Ms Donaldson's evidence, and I confirm that I agree with the transportation related conditions. Following my assessment of submissions received in Council's Section 42A report and the accompanying transport related technical report, I remain of the view that this proposal can be supported from a traffic and transportation perspective, and all potential effects are appropriately mitigated through conditions of consent. Let's check one question. So it's fair to say then that the the data gathered during the period where the cruise ships were frequent is perhaps more of an anomaly, and we don't see that level of activity now. Yeah, so the transport perspective anyway. Yes, absolutely. The 2018-19 survey did capture the summer peak, which is very useful. And in my evidence, I broke the daily data down into when there was a cruise ship in Akaroa Harbour and when there wasn't. And there were two very different levels of activity that were going on. Yep. And the subsequent 2021 survey, which captured, was February through April, so it did capture the Easter period of activity where things are very, very busy. That aligned with the 2018-19 survey when there were no cruise ships. So it was the cruise ships that were creating perhaps unforeseen demand, and with that, quite a lot of intensity along the corridor. In terms of creating the footpath on the northern side of Belgrade, at the moment parking is relatively pedestrian activity. There's no concerns of creating a footpath will effectively push cars more in towards the street with parking. There's sufficient width within the road reserve to have the footpath and allow vehicles to pass up and down still. Yes, so Rue Belgrade, the road width, the cross section does change at different points along the corridor. And you'll notice in attachment A to my primary statement of evidence, this is the agreed design with council. We've been closely with council for quite some time to come up with an agreed solution. You'll notice that there's yellow dash lines from the start of the footpath through to just past Rue Cachalot. That's because that's the narrowest part of that corridor, where, in my view, there isn't sufficient room to have cars parked on both sides of the corridor. So that's why yellow dash lines are proposed there. As you move further towards the application site at number 74, you move from about, I think it's a 7 metre carriageway to about, or 7 metre sealed section of the carriageway to about 9 metres. So there is more generous provision there for the vehicles to be able to pass each other. And I think reading into a statement, the buses coming up through Belgrade, turning into Rue Cachalot, and then reversing. Done relatively safely. Given it's a straight road, there's plenty of visibility for cars that may come halfway through the manoeuvre. So when I took my site visit, I timed it when there was a large coach arriving at the site and then leaving the site. So I have observed both the arrival manoeuvre and then the departure manoeuvre. It is that departure manoeuvre which we are proposing becomes the one manoeuvre for both the arrival and departure. So they come into Rue Cachalot forwards and then they back up Rue Belgrade It is a straight corridor with good visibility. I had a conversation with the driver as well to see if he had had any close calls or safety concerns, which he hadn't. I asked about the driver briefings, and he elaborated that the drivers are well briefed in terms of what the protocols are for visiting the site. And I inquired about the safety features as well. So he did say they've got reversing cameras and there's audio warnings when the coaches are reversing. So if a vehicle were to be coming, there's good visibility between them and there's sufficient width there for the vehicle and the bus to be able to get around each other if necessary.
Are you aware of any other situations around perhaps the Christchurch district where the similar manoeuvres or buses are required to reverse, like to get to the, I guess, the pick up or the drop off point?
No, there's none others that do spring to mind. One of the fortunate things about this environment in terms of that reversing is that it is a quiet street. There's approximately 150 to 200 vehicles per day on the east side of the application site. So if it was a heavily trafficked street, I don't think it would be appropriate. And in any event, we have offered a substantial mitigation in the form of a footpath on the north side to separate out vulnerable road users from vehicles that are manoeuvring in the roadway.
And if the consent was granted, then presumably too, it'd be appropriate for a review condition anyway that would allow council to revisit that arrangement should problems occur in the future.
I'm not sure if a review condition has been offered at this stage. I know there is one relating to the maximum cap of 80, which Mr. Downard Wilker and I have agreed is no additional traffic management planning is required at that point. So I understand there was a review condition relating to that.
I know you've inquired into the Whakatahi crash statistics for the site, and there's none of note. Are you aware of? Are there any traffic counts that indicate when the busy periods of use on the road actually are? Does it coincide around the beginning of the day, end of the day? That kind of.
That's it's not something I've looked into in detail. The source of the traffic count is a publicly available resource called Mobile Roads, which creates a quite extensive network of traffic counts and where traffic that have been sourced from local councils. And where those traffic counts are unavailable, provides estimates around those. Based on 150 to 200 vehicles per day, I would anticipate that given the environment is predominantly residential, the peak hour is a rough rule of thumb we use is 10% of the all-day count. So there'd be 15 to 20 vehicles in peak hour two-way would be what I would anticipate, which is one vehicle every 3 or 4 minutes. So it perhaps gives you a bit of a gauge as to it's a relatively quiet corridor in that regard. And look, that's consistent with my observations during the site visit when there were only a couple of cars that actually went past during the period.
I think it's important to note too that we're not, every day is not the same, and every day won't be, I guess, experiencing that ultimate level of traffic, will it? Because there's periods in time when the town is quiet, or say in winter time when there's less visitors, there's less activity.
Yeah, absolutely. And look, that's one of the very useful resources that I had in order to be able to support my assessment, as I had the November 2018 to February 2019 data. I then had the February to April 2021 data. I designed that specific survey to collect information, so I'd have a good understanding of the traffic environment. As a note in the summary statement there, 4 vehicles was the average number of vehicles that were parked outside at any one time. When I broke the numbers down a little bit further, there were somewhere in the order of 10 to 15% of the time there were no vehicles parked outside. So there are times where it's very, very quiet, and this is during the summer season. So there is a spectrum there. Which is clearly now capped with a maximum number of visitors.
Okay, so given that the number of people that are on site at any one time, and that some of them may stay all day or for longer periods, you're still satisfied that the parking is appropriate in the street, that there's no significant overlap?
Yeah, the manner in which I've made my assessment is based on an average occupancy stay of roughly an hour.
Yeah.
If people stay for longer, then intuitively the effects would be less, because you don't have 80 persons walking in the front door every hour, 80 persons leaving. If it were shorter, which seems perhaps unlikely given there'll be more visitors to be able to view, and my understanding from Ms. Martin is that the average stay is roughly around about an hour at the moment, so I anticipate that the effects may actually be less because of that cap of 80 if people were to stay for longer.
A number of the submissions and concerns raised were around vehicle emissions. And I think the remedy to that seems to be the condition around requiring that buses idle for no longer than 5 minutes. You're satisfied that can be achieved?
I can't see why a bus would choose to idle for more than that. 5 minutes is certainly ample time for a coach to load up or to discharge its passengers. I certainly support that condition.
Yeah. So, given the way petrol costs are, it's probably cheaper anyway, isn't it?
Yeah, absolutely.
Yeah. If this consent didn't proceed, given that there's no change to vehicle numbers, probably out of scope, would you see those traffic improvements as still being necessary?
I haven't considered that point in that context. However, when I was out on site, there were approximately 50 people within the site at the time. There was a coach there, and I observed that there was really no safe facility for passengers to be able to assemble, to be able to board the coach. So that the saving grace is that it's a very quiet environment, generally speaking, and the coach would pull up alongside the bottom of the driveway, so that actually contained things. But looking at this application and the condition set that's put forward, there's some substantial positive traffic effects from my perspective, including the footpath, including the bus stop, mobility park. It's quite a long list in my view that's seeks to actually improve the overall safety and the environment, and really also control the intensity of the activity.
And given those conditions, a requirement for those improvements couldn't be imposed retrospectively on the existing consent anyway. What you're offering now becomes part of that package of overall conditions or restrictions that provide greater certainty to the community about what's actually happening in the extent of the activity.
Yeah, I think it's quite a way of putting it. If the looking forwards, if consent were to be granted, there's a fantastic new asset for the community with the footpath having been extended up past here, and separating out pedestrians from vehicles is I certainly very, very much support that.
Mm. I know that you've said there's agreement between yourself and the council's experts, so I probably don't have any more questions at this point, but I may come back to you once we've heard from the council.
Yes, certainly.
Right, but that's really helpful. Thank you very much.
You're most welcome.
We got Mr. Compton Lowen. It's just it's it has been updated since. Yeah. More. Okay.
So happy to share.
Yeah, we should.
Doesn't really go deep into my area of expertise.
Yeah, I've got. Oh, yeah. Sorry.
All right, morning.
Yes, I've got a brief summary statement that I'll just read through, and an updated landscape plan and cost section, which I'll talk through as well. My full name is David John Compton Lowen. My qualifications and experience outlined in my evidence in chief. And in assessing the proposed effects of the development, I consider that the key issues from this proposal from an urban design perspective are the receiving environment, building position, scale and form, building colour and glazing, the landscape plan and internal boundary treatment, privacy and overlooking, earthworks, retaining walls, paths, sculptures, art, signage and transport improvements to the road. The receiving environment has a high degree of visual coherence, but this is due to the existing vegetation in the area, which unifies the eclectic character of the existing buildings, which do not have a consistent architectural approach, either in terms of materials used, roof form, or setback from the street. Existing dwellings and auxiliary buildings along the road and in wider Akaroa is made up of a diverse mix of building forms, styles, finishes, and colour palettes. Both proposed buildings, Ascension building 124 square metres and the cafe building 112 square metres, are considered to be of a height and scale which is consistent with other buildings on road Valkyrie, akin to 2 and 3 bedroom dwellings, which will not undermine the character of the street. What I'm trying to highlight there is the relatively small scale of the buildings. It is of a residential scale.
There are no controls on building colour within this part of Akaroa, and this is apparent in the colours present on the nearby houses, including Hampton House. Likewise, there is no restriction on the amount of glazing used on residential dwellings. And you will see on a number of more modern buildings you see around Akaroa, they have extensive areas of glazing to take advantage of the view. It's quite a different style to the older buildings in Akaroa. The illustrations and renders shown in the application highlight the residential characteristics of the proposed building. So the landscape plan attached to provision F highlights the existing and proposed boundary planting design once established to ensure privacy from adjoining properties while screening views into the gardens. A cross-section has also been prepared through the site. When I initially looked at the development and I looked at the scale of the proposal and the character and I guess the sense of stewardship or care that's taken over the garden. It's not like an industrial development where typically people plant them and then the plants die and then, we don't achieve what we want to. I had a good level of confidence that what Josie was trying to achieve with the sculpture garden would actually happen, and it was seeing the way that she worked. I was of the opinion that at the time that you didn't need a landscape plan wasn't warranted, just in the artistic nature of her work. That you didn't want to curb that degree of flexibility and creativity. So I think what we have developed is a balance. There's a lot of detail in here, and it addresses all the edge effects, views from the street appropriately, while allowing Josie to produce her artwork within that structure. So a number of the elements, including the path and retaining walls, those will be designed at a later date. And the intention, as you can see with the other works on the upper part of the garden, they would very much work with the contours and the landscape form. So paragraph 7, I'll come back to the topic after this. The presence of earthworks, retaining walls and paths are consistent with development in hillside areas and are not considered a commercial activity. The path proposed linking the entrance building to the cafe is required to ascend a relatively steep bank and will be designed in detail at a later stage, but is unlikely to be designed to meet NZS 4121, which is a standard for accessibility into buildings, car parks and access ways between commercial buildings. And in my evidence, I mentioned a number of different sculpture gardens where it's pretty much the same principle applies, that you do try to make spaces and paths accessible as possible, but sometimes it's just not possible. The proposed existing consented freestanding sign is moved from the driveway to in front of the cafe building. No adverse effects are considered to result from its relocation. The traffic improvements to the Roo have been developed in conjunction with council staff and all elements which would be anticipated on a local street. There is a change in character, but one which is not considered adverse. In summary, I consider that any potential adverse effects on residential character, visual amenity, and privacy are addressed in the proposed design. I could just quickly take you to the cross section on the back. What I'd like to highlight, the person on the right-hand side is standing at road level. So originally, when the building was first proposed, the cafe, the entrance building, it was 1.1 metres off the front boundary. So that's now being pushed back to 5 metres. So that's more in line with the adjacent dwellings and where the previous dwelling was. You can see from the scale of the buildings, they're still relatively low in stature, and something that you would anticipate in a residential area. And then there's the ability for a lot of landscape planting within that space between the entrance building and the cafe to help soften views of the cafe building. Partial glimpses would probably still be possible, but that in itself is not an adverse effect. And this cross section doesn't show the boundary treatment with the adjacent properties. Obviously, it's a section, so rather than a section elevation. Oh yeah, so we've added a couple. The existing plum tree is shown in the front, or as close as we can get to it, and then we've actually added an additional pittosporum at the front, and then also magnolia mid-level. And I'd probably see this as the minimum level of planting. Obviously, Josie, when she comes to actually do the planting, there will be additional plants added to that space. If you can imagine, Josie's not wanting to show off the artworks before people come into the gardens. You know, you actually have that sense of surprise and containment, and it's the landscape planting would assist with that. So the if we go to that and this is the existing plum tree, and then we've added one magnolia tree sort of midway up the path.
Thank you. Just a few questions, and probably more from around the sort of the urban design type questions. There's been a number of, we've covered off a fair bit already, a number of questions around this being a commercial development.
Yes.
The buildings that are proposed, they're small scale, residential scale. So scale itself isn't an indication of commercial activity from an urban design sense. Would that be fair?
Yes. Yeah.
So
yeah. I think the scale of the buildings complements the residential receiving environment well. Especially the cafe building, actually, when you look at that, that could appear as a residential dwelling. It's got a level of detail and human scale elements that, I mean, it doesn't appear as a commercial building. It's different. I get that, but it's quite artistic, and it's not something that I don't think it looks out of character.
Yeah. There has been some comment in submissions around the expected character of the area, making reference particularly to the colonial history.
Yes.
And I understand that design and appreciation of it is very subjective for people, but is there, in designing buildings that don't reference that colonial style, from an urban design perspective, that doesn't necessarily detract from that style, does it? Because I understand there's arguments that if you're putting the old next to the new, the old is deliberately different.
Yes, yeah, and I think when you do look at the buildings within the receiving environment, there is no consistent character. There are some heritage dwellings, and there's also some new dwellings in there. But if there's different materials in there, different setbacks. I think that's what it's trying to highlight, really, that there's no eclectic style in there. It's not like you go along the road and actually go, this has a colonial historical feel to the development. And I think that's trying a lot of design guides to, or developments in New Zealand and in most cities, that we don't try and replicate that heritage. It does happen more so overseas, but it's something that's not not done here.
And it seemed to me from when I was on site too that when you look up and down this part of the road in the area, it's heavily treed and vegetated.
Yes, yeah.
And that hides the number of houses and dwellings and buildings that are actually there.
Yes, yeah. I think what it does is it actually unifies all these different styles, and that's what provides that character. That it's not overgrown, but it's quite lush through there, and that benefits the topography as well. That it's heavily treed.
And so the intention then to have this additional site developed as more of a woodland is certainly would be consistent with that thing.
Yes, you would on the in some of the existing photos as well, and in my evidence and Miss Donaldson's, you'll see on the let's get my north and south right, and east and west, the upper side of the so there's already a number of prunus trees, cherry trees planted, and so it is heavily vegetated. It's quite difficult to see into the site from some locations, or especially that part of it. And I would say the same with the existing sculpture garden. Then when you're down on the street, apart from the entrance sign, you don't really have that awareness of what's up there.
Yep. And so the boundary plantings that some of which have already been done, given that thing that plants at least seem to grow reasonably well in this environment.
Yes, yep.
Given that the development is going to be staged to some degree, by the time everything is completed, those trees will be relatively mature.
They will.
You'd expect anyway.
They will have established well. I think it's quite interesting when you look at Google Street View and you look at Josie's Drive and the cypresses planted on there and the size of what they are now. You can see a noticeable that they've grown really, really well.
Yeah,
established well.
Looking at the conditions, there was a condition that suggested that limited the height of sculptures to 2 metres.
Yeah.
Given, I guess, the heavily treed nature of the area, the size of the site, do you think that's necessary?
No, I don't. I've read through the conditions, and that was the only aspect that I considered wasn't necessary. And some of the existing sculptures will already be over 2 metres. I do not see that being an issue at all, given the nature of the sculptures, the plantings, and the intention to actually internalise the artworks into the garden. I don't think they should be limited.
I think there was a suggestion there be a setback requirement, but beyond that.
Again, I understand that from, like in terms of people gathering close to the boundary, but in terms of visual aspects, I think we have dealt with that satisfactorily, that there shouldn't be a restriction on that aspect either.
Yeah. And that's as much as given the size of the site and distance from boundaries as it is the height of the trees and the vegetation.
Yes. Yeah.
And I think I got the point too. It's designed in a way to give an element of surprise that you're walking through and you find something else and you find something else.
Yes, yeah. And looking through the existing garden and how that's been designed, and it's very much everything's internalised within the site.
Yeah. You mentioned that the planting you've shown on the cross section is your expectation of the minimum that was done. If that was all that was done, would that still be enough in your mind visually?
Yes, I think so. Given the nature of the way Josie works with the site and the finishes that she'd proposed to the retaining walls and into the paths, I feel like it's what we've shown as a high level of landscape planting. Yeah, it addresses all my concerns. And also what we haven't shown on there is the boundary planting with the adjacent properties. So if you can imagine, we're looking at this, but then for parts, but we've got 3.5 meters worth of plantings alongside the boundary.
And there's already a significant number of trees planted in the area.
Yes, yeah. So
it's not obvious because it's what's the lead at the moment.
Exactly. Along that southern, the northern boundary, looking down on 76 and 78, there's Petinia on the fence, and then also we've got a large number of Christmas trees in front of that as well. So they'll eventually, they are already starting to be quite a canopy across the top.
So if these, say, if we were having a hearing looking at development of the site for establishing 2 residential dwellings of a similar scale to this, would you expect a similar level of landscaping from them, or is what has been proposed now going beyond what you'd expect?
Oh, definitely beyond. And I think if 2 residential dwellings were on the site, you'd potentially be looking at a greater level of retaining walls. You'd be wanting to get car movements up onto that site, so the actual earthworks could be greater than what implemented in this development.
So there's an advantage, I guess, from a design perspective of having this site developed in conjunction with the overall property. You get a consistent planting or consistent theme, or just.
Well, I think so. I think we'll get we'll definitely get a higher level of care and maintenance. Yeah, it depends. Everyone's garden's different. But I think we've got that degree of certainty that this will be kept up to a high standard.
And you're comfortable that the species are proposed are ones that will survive in the environment?
Yes, so we've looked at what's there already, and then tried to mimic that as much as possible. And a large number of the species are already planted and are doing well.
Sort of things. So many times you approve a landscape plan and it gets built, then within a year because they're the wrong species.
Exactly, and that's the beauty of this development too. That I'm sure Josie doesn't want dead plants through the development. It doesn't help the artwork.
No.
So, a lot of commercial developments are really ticking the box and then moving on. But this isn't the case with this activity.
Yeah. Thank you. I think that was all the questions I had. I think there's been a number of comments around the existing dwelling, but that's out of scope because this application doesn't affect that. So nice got that. I think that's all I had. Thank you. It's really helpful.
Thank you. We're all the same. Planning to the left. I think we're moving along.
We're doing we're not under any
well.
Pressure, so we might start for lunch and then pick up afterwards potentially.
Yeah. So Damian, another brief summary.
Danielle Marie Robertson. I'm the Principal Planner at Davis Ogilvy and Partners, a Christchurch based survey, engineering and planning consulting company. I have prepared a statement of evidence dated the 19th of June, which outlines my qualifications and experience. The application relates to the construction and establishment of a cafe, entrance building, and the expansion of the sculptural gardens on the site at 70 Rubalgari in association with the established activity at 70 Rubalgari. The proposal requires consent as a discretionary activity under the district plan. This is principally because the retail activity in place of assembly standards are not met. There are a number of restricted discretionary non-compliances that are detailed in both the application document and summarised in Ms. Cottom's report. The application is not supported by the Council's planner, who has recommended declining the application, in particular in relation to adverse effects on residential amenity. Post-notification changes include amendment to the plans, including a 5-metre building setback from the road, works within the street are no longer required, an updated landscape and planting plan, provision of an acoustic assessment, and the adoption of a maximum number of patrons on site at any one time, being 80, as well as a proposed road layout design and provision of a booking system with flexibility for walkouts. 248 submissions were received, 215 in support, 32 opposition, and 1 neutral. Submissions are grouped into the following themes: tourism benefits, protection of heritage, site accessibility, urban design in terms of the cafe and entrance building, transport effects, scale of activity, residential environment effects such as nuisance, amenity and privacy, and ecological effects. Council's planners' key concerns relate to the scale of activity combined with collective building design is not anticipated within the locality, and uncertainty of other elements, which are detailed below, results in significant adverse effects on the residential character and departure from zone characteristics. The effects of residential amenity in terms of privacy and overlooking of neighbouring residents and noise effects. There is potential for her recommendation to change if the application is modified in terms of patron numbers and landscape mitigation. And the proposal is unlikely to create a precedent, although this is potential to affect plan integrity, which has been discussed previously. Council planner generally considers that other effects can be managed through conditions of consent. In terms of noise and traffic effects, my opinion is informed by the evidence and analysis of Mr. Smith and Mr. Barron. I agree with their conclusions regarding the acceptability of these effects and consequently am of the view that associated noise and transport objectives and policies are achieved by the proposal. In terms of other community-related effects, I also rely on the evidence of Mr. Compton alone. I accept that the application will have some adverse effects on the character and visual amenity of the site and its immediate surroundings, although they are further able to be mitigated such that any design-related or visual effects fall well short of being significantly adverse. In terms of effects on privacy and outlook, I consider the mitigation proposed, including separating distances and significant landscape planting, comfortably resolve these issues and effects. The areas of uncertainty which inform the Council's planner's opinion and modifications proposed have been clarified and demonstrate effects, along with appropriate conditions of consent, are sufficiently mitigated. I consider the restriction on the maximum number of visitors on site, together with the hours of operation from 10 a.m. to 5 p.m, and the likely significant fluctuations in patronage over a typical year, will mean that in practice the scale of the proposal will not be incongruous with the receiving environment. In respect of objectives and policies, I understand that the test requires a fair appraisal of the objectives and policies as a whole, and that being contrary to means repugnant to, not just inconsistent with. On that basis, I do not consider the proposal to be contrary to the objectives and policies. Rather, I confer that the proposal achieves these objectives and policies as a whole. The Council planner does not seem to have approached the test on this basis. Overall, in regard to all the evidence and statutory considerations, I consider the proposal able to be consented on the conditions proposed.
I do have some questions.
Yes.
I think actually a number of the questions I was going to ask you have been covered by others this morning, but I did have some questions around the conditions.
Yes.
Marked up set that was provided.
Yes. Okay.
Curious about the booking system, and practically how that is going to work. And I know the point is to have a system whereby you can book coaches, but still has the flexibility for on-site for walk-ups. And I know the condition was drafted prior to open cafe for public. The system needs to be in place, and that's normal. And again, you've got the review of that for 12 months. Presumably that's because, like any system, it will take a bit of trial and error and seeing how it works, it could be refined.
That's correct, yeah.
There was a submission, I think, or a letter of support from someone involved with the tour buses who said that they're responsible probably for the majority of the different companies that come. So do you anticipate it being reasonably straightforward to work with the bus companies?
Yeah, at present with the bus arrivals, there is a system in place that Josie has, Martin has, whereby they actually have to call in advance and advise her as to when they're arriving. Okay. So that system's already in place, so Miss Martin can control it and has been to date. Okay. So that's sort of a separate I guess system to the actual visitor on site. So and as I understand that bus booking system actually works really well. And then we don't have the double ups because they all have, my understanding is there's quite a strong relationship with the various bus companies with Miss Martin as to when, and because they generally know when they're going to arrive, what sort of parties they'll have. So that's documented. Yeah.
Okay, so the issue then really becomes how do you manage the more informal visitors and the walk-ups? So presumably then once the entrance building is constructed and people can channel through that one entrance point, it's easy at that point then to keep an eye on how many are on site at any one time. So presumably the poor person on the desk has to say, sorry, there's 80 people on site, you're going to have to wait until you leave.
Right, that would be correct, yeah.
Okay.
And I suspect there'll be some sort of training that will be undertaken with all the staff to ensure that that is adhered to, and they will know the procedures and that will be put in place around, you know, if people do arrive and it's at occupancy, this is you shouldn't possibly wait in reception or come back to a later time when you know that it's actually slightly quieter. And also the local tourist operators will be advised that there is a maximum number and to advise future visitors, you know, of such. So sort of try and time your visit accordingly to possibly various times of the day, throughout the day, rather than saying 1 o'clock's the best time to go, so run some kids there at 1.
And I suppose presumably the system would allow, say I was a member of the public looking on site, wanting to come, there'd be something on the website that said there is a booking system, and so
correct.
Over time you would expect people to get more used to the fact that they should ring in, inquire and make a booking if they needed to.
Absolutely. It will be well advertised on the website and within the district.
But given that to date, it's been very infrequent, if at all, that you've had up to 80 people per hour anyway, then that's less likely to be an issue.
Absolutely.
Particularly given that this proposal isn't seeking to expand the activity.
It's more about control.
It's about control. But in any event, that draft condition that talks about the review of that system would be appropriate anyway.
Yeah, and those numbers and things will be available to
Condition 11. Well, originally drafted said prior to the commencement of the expanded activity, ensure that the works in conditions 8 to 10, which is the parking improvements. Is there a difference between saying on commencement of or prior to commencement of?
I guess prior to the commencement of could potentially infer that the works need to be undertaken before everything is completed on site, rather than on completion of the various overall activity.
Curious about the condition we originally talked about outdoor maintenance and the noise that can generate. And that's possibly a factor of this being a large site, a heavily treated site, such as surrounding neighbourhood properties. It wouldn't be uncommon for people to use noisy equipment to maintain the trees on their property.
That's right. Would anticipate noise associated with landscaping,
gardening, tree trimming,
as a part of the environment. No, in this instance, but
cover off the cafe. And again, Mr. Contamara and the condition around sculptures exceeding 2 metres in height.
Yes.
From a planning perspective, you wouldn't think that necessary?
I don't think that's necessary either. I think they will be contained within the site, and I think the setback from the boundary also enables sufficient hunting around the periphery. And as we know, it's very much you go on site and you're surprised at every turn. So if they're visible, it sort of loses somewhat of that surprise element. So I think the 2 metres in height is the restriction's not required. I think it can be set within the environment so that it's nicely screened and it's not obtrusive.
Yeah. think just around the duties and policies. The places about proposal not being contrary to the policies, and I understand what you're saying, and that the application is consistent. As a discretionary activity, you're not required to demonstrate that the effects are contrary or not. In terms of, as I understand how Section 104 works, but when you look at that, the overall approach of considering all the duties and policies, I think the outcome is the same. What you're really saying is that there's nothing in the application that's inconsistent with the policies for the residential zone in this part of.
That's right. Yeah, that's correct.
A number of people have been concerned about, I guess, this being a commercial activity, with there being a retail component. The fact that this is the cafe offering is limited to patrons only, would you see that as setting that apart effectively from a standard retail commercial type activity, setting aside all the visitor activities that are going on?
I think it forms part of sorry, when you say it's separating that, sorry.
It sets it apart from a standard cafe in town. So.
Definitely, it's very different. The cafe is providing service to those already on site, rather than people. I'm not 100% sure, but I think it'd be very different than someone that's just going to pop into town for lunch or coffee ad hoc. They would only use this facility whilst there. I don't think you would purposefully just go to use a cafe and pay an entrance fee on top of your.
Yep, no, I agree. That's fine. That's what, make sure you're happy with it. I think covered. You've been the planning witness and going last. Everyone's covered what you're going to say. One of the elements of the policies talked about development not precluding future development, residential development of the site, and you wouldn't see this application as doing that. So if for some reason in the future the site was abandoned, it could be turned over and used for residential.
I mean, it's of such a scale anyway that it's 1,400 squares. So I don't think it would preclude future development
if that was ever an issue.
Was ever to be reverted to that use.
Yeah, and in terms of, we talked this morning around activities being necessary in support of historic sites to provide towards their maintenance, and I guess that goes. I think the fact that this is I can't remember the exact wording, but this is the activity goes towards supporting the house. It's functionally dependent almost. The two can't be viewed in isolation.
Well, that's right. I think that's correct. That's support the ongoing maintenance viability.
I think
of that particular item in setting.
Yeah, so the policy I think talks about this strategic or operational need to be located on the site. So this proposal wouldn't work if it was located anywhere else.
I don't think so. Given that it is a heritage.
That's right. Yeah, and that's right. I think that just because it's heritage listed doesn't mean there's any funding available from the state to protect them. No, it's really very much to the applicant. So. think that's all I had at the moment. So I know that the council officers will respond to the changes we've promoted. So there may be some more questions to come.
It's fine.
At that point.
Yep.
But for now, I think that's all I had. That's, yeah.
Thank you.
Okay. Well, that takes us to the stroke of lunchtime, which is proceeded a lot faster than I thought we might have. So that's fine. Was there anything else that you wanted to cover off at this point?
No, nothing that I can think of. Again, sort of, in terms of the engagement between the experts on conditions and matters of detail, which the applicant obviously welcomes that.
Yep.
And there's certainly an opportunity. We're all in the same room, so
that's right. There's things that are outstanding still.
Any input from submitters on the conditions as well. It's obviously welcome.
Well, we do have some room now in the timetable because we were due to break until 1 and then carry on, but we can take an extra half hour and longer lunch.
Yeah.
Because there are a number of people and might put the cafe downstairs under pressure.
Yeah.
We weren't due to start again with submitters until 3 o'clock.
Yeah.
So we might make some inquiries and see if there are some who would like to go earlier this afternoon.
Right.
Either those in the room or those online.
Mm-hmm.
So at this stage, should we break until 1:30?
Yep.
And then we'll come back and then we can work out the order for the afternoon.
Righty.
At that point.
Okay.
That suits.
Apologies for being too.
No, it's always you can never tell how long it's going to take. So
yeah.
Uh, Damn it. Hmm.
Let's get Axel quickly. Try to signal them.
Yeah. Right, welcome back everyone, and thank you for accommodating our somewhat further timetable. We are running ahead of time, so it's great that we can have some flexibility. So first thing that we have is Victoria Andrews online. Can you hear us okay?
Yes, can you hear me?
Yes, we can. Thank you.
Okay, thank you.
Now I've read your submission, so happy for you to present whatever you like to us this afternoon.
Thank you. I'd like to discuss several points, including those raised in the 42A planning report. I generally support the planner's report with one exception, which is setting a precedent. The points of my submission are, number one, the applicant exceeded the level of commercial activity in the 2001 resource consent. The current application was notified based on the recommendation of Commissioner David Mountford, who highlighted the fact that the applicant had exceeded the level of anticipated activity in her 2001 consent with regard to the cafe providing light lunches, teas, and coffees from Linton. The tourist activity greatly increased in terms of scale and level of activity to include concerts, performances, workshops, and garden visits. Vehicles congest Rue Balgary, and transportation has often been provided by large buses that block the street. Parking takes place on the unformed road verges where pedestrians are required to walk. In addition, large visually intrusive signage was installed. As Commissioner Montford commented, the business had clearly been successful and that, quote, the level of activity is clearly not the small scale level envisioned in the 2001 consent, end quote. Profit from the expanded tourist activity has more than covered the maintenance cost in relation to the upkeep of Linton, a Category 2 listed building. An increased level of tourist activity, therefore, is not justified or warranted in this regard. Number 2, setting a precedent for the level of commercial activity in an Akaroa residential zone and its impact on residential character and amenity. The application, if granted, would support an increased level of commercial tourist activity, which is located in a quiet residential zone of Akaroa. If allowed, the application would definitely set a precedent for anyone wishing to establish or expand a commercial activity in the context of Akaroa's residential setting. District plan rules, policies, and objectives are clearly stated. They exist for a reason, and they should be upheld. If the activity is allowed to proceed, it will be difficult to not deny others the same right and level of commercial activity. There are numerous B&Bs in this residential zone. They too may wish to expand into commercial tourist activities in terms of size and business opportunities. It would be hard to deny property owners similar treatment if the resource consent is granted. Akaroa House, Banks House, Blythecliff, Buford House, and Mill Cottage spring to mind. All of these B&Bs have historic character, and 4 are very grand residences in terms of scale, and several have well-established large gardens. Blythecliff and Mill Cottage are important buildings, and both have extensive gardens with the potential for greatly enhanced tourist activities. In this context, it should be noted that Linton started out as a B&B 20 years ago. The applicant proposes to demolish an existing dwelling, which will be replaced by a contemporary gift shop, gallery, and ticket office. At present, Akaroa has a housing crisis. Young adults, seasonal workers, and families are leaving the town due to the lack of rental accommodation and affordable housing. Dwellings, in my view, should be retained to provide housing for individuals living and working in Akaroa. They should not be demolished. The acoustic report does not take into consideration the fact that sound carries across valleys and the hills of Akaroa. Due to the high position of the tourist activity, noise from visitors, inclusive of weddings and large gatherings with music, will increase the level of sound, which is a serious nuisance for those residing in proximity to the activity. I know from my own experience living adjacent Greyhound Valley Road that traffic and visitors can be loud and noisy from October through until April on an annual basis. Walkers and trampers often shout and children scream. Even with our double glazed windows closed, we can hear groups throughout the day. So I have real sympathy for the property owners in the vicinity of Linton, especially if they are working from home. The long-term effect and impact of the proposal will distract from the amenity values of the residential area, as well as impacting a sensitive streetscape which merges into a quiet rural setting. It should be remembered that the center zone of Akaroa allows for mixed use. The residential zone generally does not. Linton has a Category 2 listing. It is positioned high above the street in the residential zone of Akaroa, allowing a contemporary, brightly colored, whimsically designed cafe in excess of a 7-meter height restriction would overshadow and distract from Linton, which is a stately historic building. The excessive height and style of the cafe, if allowed, and the additional large sculptures would draw greater visual attention to the tourist attraction, which I assume is the intention of the proposal. The ticket office is also a gift shop and gallery. The building's style and commercial character is out of context with the residential amenity and setting of the streetscape. The overall design distracts rather than enhances the amenity values of the residential zone. The building does not reflect or complement materials used in nearby houses, and its character is purely commercial in style and intent. If the consent is granted for the level of tourist activity to expand to a significant degree in a quiet residential zone, the applicant, in my view, will have a distinct market advantage over businesses operating within the town center commercial zone of Akaroa. My third point is elderly and disabled access and the lack of alternatives. The desire to provide improved accessibility to the tourist attraction for those who have mobility issues is, in my view, a red herring. There is no need to accommodate a zigzag pathway, which will be similar in terms of steepness and difficulty to the existing access via the driveway. A simple solution could have been instigated years ago. A small electric van similar to those used at Zealandia in Wellington could safely transport children, the elderly, and individuals with mobility issues via the existing driveway at a very modest cost. However, providing an alternative would have made the current application more difficult to justify. In my view, the applicant intends to increase the level of land use activity to enhance commercial revenue. Therefore, alternative solutions have not been provided in the application. In conclusion, in my view, the applicant is a highly motivated and successful entrepreneur. If allowed, the new enlarged cafe, visitor center, ticket office, gift shop, display area, and the expanded sculpture garden will benefit the applicant with enhanced commercial profit at the expense of setting a precedent for what is acceptable in Akaroa's rural or residential zone. The proposed level of commercial activity far exceeds what is acceptable in Akaroa's quiet residential zone. Residents in the area have experienced a notable loss of privacy, as well as the quiet enjoyment of their homes, and their discomfort will only be increased if consent is granted. I accept the tourist activity and attraction may be popular with regard to visitors as well as some residents and tourism operators. However, the economic benefit to the township, which has yet to be documented with accurate reference statistics, should not be allowed to override or outweigh the policies and objectives of the district plan. And in reference to that, the residential zone for Banks Peninsula says, the zone includes the settlements of Littleton and Akaroa, which each have a distinctive urban character. Akaroa is a smaller settlement characterized by its historic colonial form and architecture, relatively narrow streets, distinctive residential buildings, and well-treed properties. Akaroa is a focal point for visitors to the region and the district. The character of these two settlements is highly valued, and the district plan provisions seek to retain that character. That's taken from the district plan. In my view, incremental change, as represented by this and the two previous land use consents, are a slow death by several cuts. As Judge John Jackson said in the Environment Court many years ago, the first cut is the deepest, and in my view, if granted, the current application would be the third and deepest cut of all. In my experience, conditions attached to resource consents are rarely, if ever, monitored by Christchurch City Council. In this instance, the recommended conditions fail to include a penalty or bond for non-compliance. The planning officer assumes the applicant will provide accurate records and will self-monitor activities on site. I do not share the officer's confidence, since the applicant has already exceeded what was anticipated in her previous consent without consequence or penalty. And the desired outcome I seek is that the application be declined in full. Thank you.
All right, thank you. Thank you very much. Just a couple of questions from me, just to clarify a few points that you've made, because I think most of what you've said has reiterated quite eloquently your the position in your submission. You made a comment about profits to date covering the cost of maintenance of Linton. And I'm just not too sure what information that was based on. Is there publicly available information around costs that would allow you to reach that conclusion?
It's based on the fact that Akaroa has a number of historic buildings and property owners are required to maintain them. Quite often it's a very expensive ordeal for property owners, and I have high regard for those who maintain their properties. Without private property owners maintaining their historic buildings, Akaroa would be at a great loss. I have no firm statistics that I can reference, except for the fact that the Giant's House, to my knowledge, has been highly successful. And from the articles I have read in the press and the numbers of visitors participating on an annual basis at a rate of whatever it is, $22 per person, one can only assume that the financial gain has been adequate to meet the needs of the applicant with regard to maintaining an important historic building. But I cannot verify that other than referenced information contained in several press articles.
Okay, thank you. Just on that then, I guess you don't think it unreasonable that owners of historic buildings have some kind of business opportunity available to them to help offset the costs? Because it would be an enormous burden otherwise.
No. I think you're misunderstanding my comments. This is a third application to expand an existing business. The business has been quite successful, but I would assume that the revenue has been more than sufficient to provide an income to the applicant in relation to whatever she wishes to do, and also to maintain a historic building. Property owners, and especially in Akaroa, many do have B&Bs, which provide a degree of income to help maintain not only their financial well-being, but their historic homes. So I have no qualms with that whatsoever. It's the expansion, it's the extension and the loss of amenity in a residential zone, which, as I referenced, Mr. Montfort commented had far exceeded what was ever anticipated. I think small scale businesses are fine so long as they respect the character of the area, the requirements and policies of the district plan, and they have regard for their neighbors.
Thank you. That helps me. In terms of concerns around the two new buildings, were you listening to the applicant's case this morning?
No, I had a previous appointment. I'm sorry.
Okay, so you're aware of changes the applicant has now made in response to submissions in the in the planner's report?
I've gone through the information that was provided online.
Okay, so the applicant now is proposing a cap on numbers to no more than 80 per hour, so placing some limitations on the proposal. Does that go some way to alleviating any concerns?
No, it does not. It does not. It doesn't. Okay. Because I think it's difficult for individuals who live in Christchurch and large cities to understand the small scale of Akaroa. 80 visitors per hour may seem to be a small number, if you're living in a high rise in Christchurch. If you bring that over to Akaroa on a very narrow residential street, which is already busy from October through April, it becomes an encumbrance in many regards and makes the area even more congested. One of the most congested points in all of Akaroa is the lower part of Rue Balgaree near the Bank of New Zealand building and the service center. It is highly congested. And what seems to you to be a relatively small number of 80 per hour in terms of visitors, actually, given the scale and context of Akaroa, is quite large. And I again would emphasize the need, if the consent is granted, to have appropriate monitoring and verification of all the information that is required. I think it's hard to understand how busy and congested Akaroa becomes, especially, say, from Boxing Day through January, February, March. It is highly congested. Today, you could do anything you want. I mean, it's a rainy, horrible day and nobody's in town. It's not like that during the peak summer months and busy weekends.
Thank you. You mentioned one of the characteristics of Akaroa that's mentioned in the district plan is the highly treed nature, and that's certainly evident from walking up and down the street and seeing the extent of vegetation and how well it screens and hides houses and buildings. Do you not, or do you see this this proposal not being consistent with that, or do you think the fact there are going to be trees and plants and effort over time to creating a woodland on this second lot is being consistent with that character?
I think the existing nature of the sculpture garden is not consistent with the existing streetscape of Rue Balgaree. The sculptures are quite large and brightly colored. The vegetation may or may not take place. And in my experience, vegetation can be reduced or cut back. I don't think that is a mitigating factor per se. And traditionally, if you're looking around Rue Balgaree and some of the lovely residential streets of Akaroa, you'll see many, many trees, cottage garden, white picket fences. They are basically small scale and harmonious with the historic character and amenity of the area. The applicant is quite bold and outgoing in terms of color and the use of enlarged sculptures. I do not see that as being in character with the historic setting of Akaroa and the current streetscape of Rue Balgaree. The historic area goes partway up Rue Balgaree and it stops about 2 blocks short. Therefore, the historic area criteria does not apply to the applicant's location. But yet the streetscape, in my view, is highly sensitive with or without the historic area registration. And as a long-term resident of Akaroa, I hold that in very high regard, as do many visitors to the area. And if we start to lose and dissipate that, we're killing the goose that laid the golden egg. We do need many active, enterprising commercial activities. I have no qualms with that. The problem is the location.
Thank you. Just the last point, I think, around the district plan. The district plan objectives and policies anticipate or provide for the expansion of existing commercial activities in residential zones, provided that a number of things are met. And one of those is that there's no significant adverse effects. So the applicant has now proposed a number of conditions that limit what can and can't be done on the site. And I think I've already asked this, but I just wanted to clarify that you don't see the conditions that are now imposed or suggested as being sufficient to protect the amenity of the surrounding area.
No, I do not.
Yeah. Okay.
I think it's a well-established, highly valued tourist attraction, but I do not think it's warranted to allow it to expand further into a brightly colored, ornate cafe and a commercial ticket office gallery hard on the street, which is totally out of character with a streetscape. I think that is a step too far. The business has been allowed to expand. It has been successful, but I think at this point it needs to be curtailed and contained as it is at present.
Great, thank you. That's a really helpful summary. I don't think there's anything else that I wanted to ask you from what you'd said. No, that was all. Thank you. No more questions from me, unless there's anything else you wanted to cover off.
No, I appreciate your time and consideration. Thank you.
Okay, thanks very much. All right. Are there any other submitters here who want to go early? Since we do have some available time. I know that some were expected a little bit later on, but
I'm happy to go now. Time suits John Marsh.
Yeah, thank you, Mr. Marsh. No, we have no defined times for anybody else, so you're free to jump up and fill the slot now if you like, and wherever you're comfortable, you can come and join us at the table.
Yeah,
That's it, mate. Take the corner seat.
Sure.
And become a submitter. If you want me to disperse it, I have to pass it on.
Is this your submission, John, or is it different?
It's my submission.
So it's is this, sorry. Mr. Marsh, is this the same as the submission you put into council, or have you expanded on it?
I have expanded on it.
Okay.
It's significantly the same, but as the proposals developed, I had to change things a little bit too. With your permission, I'll just read the whole thing. Otherwise, I'm
sure. If there's parts you want to skip over or have us just take as read, if there's quotes from the district plan, happy for you to skip over that. If there's quotes from the district plan, happy for you to skip over those because I'll read them anyway in my own time. But happy for you just to take us through as you see fit.
All right. Well, I'll launch. Thank you. My name is John Marsh. My wife Leslie and I have been the owners of the property at 78 Rubell Green since December 2002. We purchased this as a family holiday home and have enjoyed its relative quiet, well-treated surroundings, native birds and the nearby rural surroundings of the Akara urban edge for most of that time. The northeastern corner of the application site at 74 Rubell Green shares an 18-metre boundary with our property. This is on our south boundary. In background, for around 12 years after we purchased our property, till around 2014, the site over our south boundary remained as an overgrown lot with many weedy trees, including wattle and sycamore. There were also a few totara, lemonwood, nio, and crimson flower and gum. And from time to time, we needed to trim the wattles when they leaned over into our property. And a storm around 2008 blew a number of them over almost onto our roof. We were unaware the property was owned by the current owners at this time, and we always had the expectation that someone would build a house there. The early developments at the Giant's House. We were aware that consent had been granted for the Giant's House to operate as a commercial activity from 70 Rue Balgary in 2001, and saw this as an activity that was complementary to the Linton Historic Homestead. At the time, it fitted relatively unobtrusively into the residential character of the neighbourhood. And Linton was secluded, being on a rear section some 60 to 80 metres from the road and behind our other street front properties. The vacant land behind the roadside properties was also well treed, and Linton was not really visible from the road. And that's a photograph from the real estate agent in 2002, which we just see the chimney of Linton protruding above all those trees. There didn't appear to be a lot of extra traffic generated by visitors, though we did consider it could have a negative impact on the privacy and quiet of those properties adjacent to or sharing the accessway. I've always considered the large sign, approximately 3 metres high and 1 metre wide at the bottom of the number 70 drive, an intrusion on the streetscape. It was around 2015 and 2016 that we became aware that the property over our rear boundary was owned by the present owners, and heard that there were plans for a house immediately behind us. It was also around that time that the site was cleared of virtually all vegetation, and some preliminary earthworks were undertaken, forming rough tracks around the site. Not long after this, we heard of the new entrance building and cafe proposal, and in September 2018, we received a letter from Ms Martin with City Council form requesting our approval as affected persons. Ms Martin invited us up to her garden to explain her plans for the business expansion shortly after this. We had a strong impression from this discussion that the entry building was to be a distinctive and different element in the streetscape to announce the Giant's House attraction to anyone passing by. Since this meeting, we have watched keenly as the consent process developed. And having a personal interest in garden design, we visited the garden at Linton on several occasions and have been impressed by the garden structure, the bold use of planting, and eccentric and cheerful sculpture, as well as the thorough attention to soil management and plant health. Our submission on the application for land use consent, expanding an existing business activity in the Rural Banks Peninsula zone, addresses several aspects of the proposals. First, of this residential character, traffic, earthworks, and fencing will be the others. Residential character, the Christchurch District Plan contains a set of objectives and policies which together provide a framework for assessment of resource consent applications as required by the Resource Management Act. Now, you don't want me to read this out, is that what I understood?
I'm happy for, given the quotes from plan, I'm happy for us to skip over them, but if there are particular things you want to highlight, feel free.
Okay, well, Chapter 14 of the District Plan focuses on residential areas, and I quote policy 14.2.6.1, residential coherence, character and amenity. Ensure that non-residential activities do not have significant adverse effects on residential coherence, character and amenity. It then continues 14.2.6.3 policy, existing non-residential activities enable existing non-residential activities to continue and support their redevelopment and expansion, provided they don't have significant adverse effect on the character and amenity of residential zones or undermine the potential for residential development consistent with the zone descriptions in table 14.2.1.1a. The characterisation of residential Banks Peninsula zone is outlined in table 14.2.1.1a as follows. The zone includes the settlements of Littleton and Akara, which have a distinctive urban character. Akara is a smaller settlement characterised by its historic colonial form and architecture, relatively narrow streets, distinctive residential dwellings and well-treed properties. Agora is a focal point for visitors to the region and district. Non-residential activities that are not compatible with the character of the residential Banks Peninsula zone are controlled in order to mitigate adverse effects on the character of the area. At this point, the resident character of Rue Balgaree. At this point, I'd like to consider the Rue Balgaree neighbourhood character as it is at this time, and as it is that the proposed extensions to the Giant's House either will or will not impact on it. In Appendix 1, at the end of the submission, I've prepared a document titled An Analysis of Rue Balgaree Neighbourhood Character and Identity. This draws on my experience as a landscape architect since 1980 and having spent some 15 years working with urban design projects up to 2014. I won't go through that whole Appendix 1 at all, but I'll read my conclusion from it. The neighbourhood character of the residential Banks Peninsula zone and Rue Balgaree, as experienced by residents and visitors to Akaroa, unfolds as a sequence moving from the western end business area to a dominant residential phase as one progresses up the valley, and then to a semi-rural residential edge before entering the rural area. It is a gradual and logical sequence from the busier part of the township to the quieter rural residential edge. The proposed developments at 74 Rue Balgaree would be located in the semi-rural residential edge. There is cohesion of built form created by the scale, form, roof pitch, that is, and fenestration, or the arrangement of window and door openings of homes. There is a recognisable texture or pattern consistently occurring here that gives the neighbourhood its character. Trees and other plantings contribute significantly to this, providing a residential setting that has a high level of amenity. While there are a number of properties with buildings and gardens that stand out and are quite charming in their style, character, or heritage value, they all contribute in a modest way to the Akaroa character. There are no properties that strongly contrast in an unexpected way that dilute that character. Two properties that are more modern in their style have a relationship in the scale, arrangement of windows, and degree of screening or setback, which minimises their intrusion. This cohesiveness results in a peaceful, harmonious ambience to the street, and this is the setting or context that the proposed new buildings need to be considered against. As an aside, there are parts of Akaroa that have had more recent building developments that are not visually compatible with this character. And for example, the rectangular apartments on the hill behind Gaiety Hall. There are also several very visible properties along the harbour frontage opposite the beach. These don't contribute positive to the Akaroa character. Over time, as more of these buildings appear, the village will become truly eclectic and no longer be characterised by its historic colonial form and architecture. I don't believe this is the outcome that the district plan seeks to deliver. Now, I just go through the Giant's House proposed developments, and excuse me if I'm repeating a lot of what I've said. Following sections are descriptions of the proposed new buildings and peripheral properties proposed for the business. Cafe description. Cafe to be located on the centre rear of 74 Rue Balgaree, a short distance to the east of Linton Homestead. 205 square metres in floor area on 2 levels. Most prominent elements of the building are the upper floor cafe windows, which curve in a 9 metre wide by 4 metre high line across the north elevation between 2 rounded turrets. A steep monopitch roof is approximately 9 metres above ground level above the windows, sloping back to the south. The turrets are shown in yellow corrugated cladding on the conceptual drawings. There is a 2-level eastern wing to the building clad in ply, board and batten, as is the cafe lower floor. The lower floor has French doors out to the garden on the north side. The south elevation, as viewed from Linton, will appear as a single level building set at a height to allow an easy transition from the existing garden to the cafe. The deck links the two, also providing access to steps and a ramp down to the lower garden. These steps and ramp were constructed several years ago in anticipation of the current proposals. In this elevated location, the cafe cafe will be visible from below as one travels up or down Rue Balgarie. The entrance building, the perspective sketch from the application documents, which I have in Figure 4, illustrates the entry building with the cafeteria above and behind it as viewed from the street. The entrance building in its now amended location is to be set back 5 metres from the road, replacing the existing cottage. The building has a floor area of 124 square metres, a little larger than our house at 78 Rue Balgarie. The main part of this building, where visible from the road, is circular in plan, clad in 3.3 to 3.6 metre high glazed window panels forming a curve across the north elevation. These are in the order of 7 to 8 metres in width and constitute approximately 35 to 40% of the site. A full height plaster rendered wall extends from the east of this central structure towards the side driveway. To the west, there is an entry space with a wide ornamental Cortian steel gate that extends to the boundary. Accessing three routes. The driveway, as shown along the east side of the site, terminates at a timber fence set back approximately 9 metres from the road boundary. I'm presuming this fence will act as a gate as the drive continues a further 14 metres behind the fence to the rear of the building. I just note as an aside, there's also a note which says driveway gate on the plan, and this is on the road boundary, and another note which indicates the line of the curb also on the road boundary. I believe these are drafting units. An earlier plan has shown cycle stands in this front drive area alongside the building, and I imagine that these will be located here if the condition referred to in the appendix for the traffic assessment period is required. And that is a photograph in Fig 5 of the front of the building. The grass verge, prunus tree, and the cottage just on the right. Pedestrian access to the entry space in buildings is via a ramp starting at the road boundary and cutting diagonally across the frontage. There are also 4.5 metre wide concrete steps at the northeast corner, starting approximately 1 metre inside the road boundary, and these meet the ramp at the top. It's understood that a bus passenger sit-down and footpath hardstand area will be required across the current grass berm to facilitate this entry. There is currently a generous gradient from the curbside up to the site boundary as illustrated in Fig 5, which is approximately 1.2 metres rise at the centre of the boundary. The berm will likely need to be modified with a retaining wall to allow for this access. This needs to be clearly shown on the applicant's drawings, as they currently suggest that the grass berm will remain. Not shown on the plans, but noted in the text is the existing signage, approximately 3 metres by 1 metre, to be relocated to the front of number 74. And this is shown in Fig 6 below. And it will remain a significant element in the road. Signage for the bus stop is also proposed. There may also need to be no parking signs for the possible mobility park and pedestrian crossing signs. I note that there is also an existing timber power pole at the northeast corner, which adds to the general busyness of that area. Planting, and I refer only to the road frontage, indicative planting here. 3 trees are shown to the north of the building on the perspective sketch and plan, a tree in the entry area and some lower planting against the northeast wall of the building. Also a narrow planted strip on the boundary in the entry space. One of the trees, the existing plum in front of the property, is shown to the east of the proposed steps. Now, this will survive the duration of building and excavation that will take place around it, but no doubt a suitable replacement could be made. The tree on the west side of the frontage, shown on the west side of the frontage very close to the gate, should be given more space if expected to grow to the size as shown. Also note an existing nia tree in the berm at the northeast corner of the site, also shown in Fig 5, will probably need to be removed to allow the driveway and footpath to be built. I'll move on to the traffic proposals here, and I list the upgrades in Rue Balgarie proposed to facilitate the visitor traffic coming to and from the expanded business activity, as these have the potential to impact on the visual qualities, character and amenity of the neighbourhood. There's a 50 metre by 2.7 metre bus stop at the road edge with accompanying signage, a bus manoeuvring space in front of 72 Rue Balgary, no stopping signs extending up into Rue Cachalot, pedestrian crossing across Rue Balgary opposite the boundary of numbers 74 and 76, a new footpath curb built out into the existing carriageway on the north side of Rue Balgary, approximately 1.2 metres in width and extending for a length of 55 metres with no stopping lines, and then a further widening on the north side of the sealed surface by approximately 1.2 metres adjacent to the paddock to extend the footpath east to the proposed pedestrian crossing. And this will then have timber wheel stops alongside it to separate vehicle and foot traffic along that stretch. I just note in the City Council consultants, the Strata peer review of the traffic consultant's evidence by Axel Downward Bookie, the following additions are also proposed should the application be successful. Sealing on the roadside berm to form a footpath and sit-down area outside the entry building with connections to the drive, ramp and steps. And this will extend east to the proposed pedestrian crossing and mobility park. A mobility car park provided for the road on the road frontage of 76 Rue Balgary. No stopping lines on the roadside opposite the entry building to allow visibility to the west from the pedestrian crossing, and 6 cycle parks to be provided on site, discounted from the full plan of 9. These are the elements that are going to be new in the neighbourhood and will impact on, or won't impact on the existing character. So in my assessment of effects of the above proposals, the application site located again, I note, in the residential Banks Peninsula zone, and this requires that residential activity should not have significant adverse effects on residential coherence, character and amenity. Talking about the entrance building now, and while the proposed entrance building is of a similar scale to many of the small homes along Rue Balgary, it has a quite unique form, style and detailing that put it into a different category than what is presently evident in the neighbourhood. It is clearly a modern architectural form with its extensive curved glazed cladding and spiral roof. This will provide an element of surprise and a point of difference among the typical homes leading along Rue Balgary and act as a beacon for visitors to the business. The elevated building site, with floor level 2.87 metres above the curb and vertical north wall a further 4.6 metres above this, will exaggerate the building's presence, further contributing to its prominence. The access ramp and steps at the road frontage contribute further to the building's point of difference and are of a scale and form more associated with a civic or commercial building, such as a community library or medical centre. The bus set-down footpath and probable retaining required to form these will add further hard landscape elements at the road boundary where there are currently no hard landscape elements. The commercial character of the business will be further reinforced by the presence of the signage, bus stop and business signage, cycle stands, and 9 1-metre high handrails, which I expect will be alongside the ramp and steps. The revised location, now set back 5 metres from the road boundary, allows for on-site planting to reduce the building's impact. And the trees as shown on the plan should become a condition of consent if the application is approved. The building form, detail of windows and doors or other peripheral embellishments cannot be said to contribute or to reinforce the present residential appearance, character or amenity of the zone as described above. Moving on to the cafe building is the size of a generous residence. So from this point of view can be considered in scale with what should be expected. It will be visible from the road as noted in Fig 4, and this is approximately 20 metres east of Linton House. The building sits very high on the site with the roof line 9 metres above ground level. By rising steeply to the north, the roof accentuates the building's size rather than attempting to minimise its presence by taking its cue from the slope. In a similar way to the entry building, the form and detailing of the cafe immediately set it apart from what is considered the historic colonial form and architecture of Akaroa, and the built form that is currently evident in the neighbourhood. The extensive use of glazed cladding, high monopitch roof and rounded turrets will be the most visible elements on the upper level, and it is these that will form the first impression of the building as a unique structure. The applicant's perspective sketch or image of the entry building with the cafe building in the background shown in Fig 4 illustrates the combined impact of these two buildings on the coherence of neighbourhood character in Rubalgary. And just look back at that picture. In Fig 4, we see the entrance building with the cafe sitting quite high. And it's a combination of these two buildings that we can see together in this frame that further increases the impact. It's not just one building with these, it's two buildings. I believe these factors will impose on the heritage character and integrity of the historic homestead. Linton will appear above and to the rear entrance, the rear of the entrance building, and a short distance to the west of the cafe in the same view. The combined effect when viewed in one frame, where they both display these new elements, will enforce the impact so they dominate the neighbourhood at this point. It would have been useful to see the Linton homestead also illustrated in Figure 4. Moving on to the visual impacts of the traffic proposals. The traffic proposals by the applicant's consultant and additions recommended in Appendix 4B will have a number of visual impacts on the neighbourhood character. As mentioned in 3.2 above, the proposed developments at 74 Rubalgary would be located in what is described as the semi-rural residential edge of the Banks Peninsula zone, the residential Banks Peninsula zone. Now, the ruralness of this neighbourhood results from the informal road edge along the north side of the street and on both sides of the street extending east of number 78. It results from the lack of formal footpaths on both sides of the street and the proximity of open paddocks alongside the road and the strong presence of trees and other planting close to the road. It's these rather informal, simple elements that we ignore most of the time, which are very important in creating that character. The proposals and possible conditions if applied will install additional asphalt footpaths along 160 metres of the road frontage. It's built out 1.2 to 1.5 metres into the carriageway. It'll install 103 metres of timber wall stops between the new footpath and vehicle. It will require additional signage for the footpath built out for the bus stop and potentially for the pedestrian crossing and mobility car park. It will require no stopping signs painted on the roadway and 6 cycle parking spaces near the building entry. These proposals will introduce new built elements to the streetscape that are in part to be expected in this zone, but there is no doubt that they will change the existing character and amenity that is currently enjoyed by residents and visitors considerably. Wheel stops proposed along the north side of the street. Cycle parks are something more associated with business zones, shopping areas, and will undoubtedly bring a more commercial feel to the streets. I'll move on to 3.4.2 or policy 14.2.6.3 of the district plan. Existing non-residential activities. Enable existing non-residential activities to continue and support their redevelopment and expansion, provided they do not undermine the potential for residential development consistent with the zone descriptions, in table 14.2.1.1a. When we purchased our property in 2002 at 78 Rue Belgree, we were shown a subdivision plan by the previous owner, Mr. McGeorge, prepared by Fox and Associates surveyors, and identified, well, the plan identified 3 sections. This indicated he had subdivided the 3 roadfront properties, 74, 76, and 78 Rue Belgree, to develop 2 new lots across the rear of the site, a total of 5 lots. That was our understanding of the titles until we more recently saw a document with number 74 as 1 lot of 1,587 square metres. We believe that the current proposals to extend the garden at Linton do undermine the potential for residential development consistent with its own description. It appears that the later revision to the subdivision plan has always been to favour the expansion of the business. Our expectation was always that there would be residential properties in the land behind us. Now, just at the back, I have got some additional notes, 3.4.2, which just on pondering on the change of a residential zone to a commercial zone. And you'll find this on the last page. I wonder what the future is for Linton and the Giant's House Garden. Essentially, it has become a business that depends on the artistic skill, passion, and enthusiasm of one person to drive it along. The garden depends on her ongoing input and direction to ensure the artistry, as well as the horticultural rigour, is maintained and refreshed as plants grow and reach maturity. Mosaics only stand up to the elements for so long. Moisture seeps into the ground, heat and frost work away, and bits will fall off. The soil needs ongoing care and maintenance, and none of it lasts forever. Realistically, the proposals we have been discussing today would take up to 3 years to put in place, possibly more. None of us are getting any younger. In 5, 10, or 15 years, maybe sooner or maybe later, who is going to be providing that passion and skill to drive it along? The point I'm making is Ms. Martin is actually the business. The Giant's House is her passion and it's her creation, and it's wonderful. But well, these things don't last forever. Will it be managed by the family? Will it be managed by a trust? Will it be sold as a going concern? Will it become one of those attractions that the Christchurch City Council decides to purchase or buy into, such as the Christchurch Adventure Pub? Pondering all these possibilities that may happen in the future. How long will this garden and business endure? What is the succession plan, if there is one beyond the next 10 years? And it will just revert to residential. So that's section 3. So I'll move on to traffic. Visitors to the Giant's House arrive on foot, by car, bicycle, or by bus. And some of these buses will be small shuttle buses, and some will be tour coaches. Staff will also visit the site on a daily basis. It is noted that no deliveries will be undertaken to the site, as staff will pick up the cafe's requirements. I expect there will be at least some deliveries that will add to the traffic over time. And gas bottles are one that comes to mind. With the degree of investment the proposals will require, I would think it only reasonable to expect that a significant increase in visitors will be needed for the business to prosper. Though this aspect has been played down by the applicant in the discussions we have had. This is not something that I've written down anywhere other than for myself, but it just doesn't seem to be somewhere a little gap in the logic that we have a heritage building, and it's understandably needs an income to maintain it, and that doesn't come cheaply. But there is a garden there which is a successful garden and is obviously allowed it to be maintained well over the years. But we're now viewing a proposal to introduce significant additions to that, which must cost in excess of $1.5 million. I have no idea how much. And that's a significant investment that one has to put into it. Moving on from that, you would expect that there needs to be a return from that investment over and above what there already is to maintain the bigger garden, which is going to be a high cost, as well as the existing garden. At the same time, we're not expecting any more visitors to come to the garden. I just don't see the logic in how this is going to contribute to the ongoing maintenance and management of the existing house. However, that's just me. I'm not an accountant. Various tables have been provided showing average and maximum anticipated traffic generation. This can only be gauged on the business as it now is. And this has fluctuated over recent years due to the earthquake disruptions and then COVID restrictions. It has, however, clearly increased its business over the last 20 years. And by expanding the garden in size by approximately 60%, adding a substantial cafe and entrance building, this expansion can only be expected to gain further momentum. The survey by the applicant's consultant, visitors by car, carried out in the 2021 autumn season has indicated 51% of visitors will arrive by car. These vehicles, as well as staff vehicles, will park on the roadside as no parking is to be provided on site for them by the business. There'll be quiet times when there is ample car parking, and there will be others when there is no available parking, making it difficult for visitors as well as residents or residents' guests to access their properties. It is these busy times that are most concerning. On peak season weekends in Akaroa, when there are more residents at home or with people visiting them from out of town, roadside parking can be fully utilised. Cars will often be parked on berms to accommodate extra visitors. This period will coincide with peak season for visitors to the Giants House. I understand from the latest application revisions that the maximum number of visitors at any one time will be limited to 80, corresponding to 45 visitors per hour. An estimated 23 of these visitors, 51%, will travel by car, equating to somewhere between 8 and 15 cars per hour. The initial application proposed that no stopping at all times markings will be painted on the road in front of 74 Rue Balgorie to allow for a dedicated bus stop. This would have been in the order of 17 metres maximum curb length, removing 2 car park spaces. The revised proposals by the applicant's traffic consultant and recommended conditions by the CCC peer review increase the no stopping at all times limitations to at least 78 metres of curb, being the equivalent of at least 10 car park spaces plus 1 mobility car park. That's a significant reduction in car parking spaces in the immediate vicinity of the business. This has to have an impact on neighbouring property owners, particularly in those busy periods. The Appendix 4B Transport Assessment Peer Review proposes a mobility car park in front of 76 Rue Balgorie as a condition of approval. This, along with the no stopping at all times marking in front of the property, constitutes virtually all the road frontage. I understand this may have been changed, but I might have missed it. Constitutes all the road frontage, leaving only a 4-metre driveway crossing for the owners to make use of. While the officer's report points out that individuals don't own the roadside in front of their property, they do pay rates for their roading, and it's only reasonable in a residential zone that you will have a degree of access to your roadside curb for occasional parking. It's unreasonable, however, to lose that amenity after 20 years of paying rates because a neighbouring business needs car parking that it is not offering to provide on site. The property at number 74 also doesn't own the roadway, though the applicant's proposals and peer review traffic condition recommendations suggest they do. And essentially they will they will be taking management of the mobility car park and the bus stop at the curbside, essentially just for their property. With careful design, a mobility car park could be accommodated up the drive of the application site and immediately behind the entry building. Proposed car parking on the north side of Route Valkyrie is to have timber wheel stops in accordance with CCC ST 626, separating the parking space and the footpath. These wheel stops consist of a series of timber beams 125 millimetres high and up to 2 metres in length. I would contend that they are not appropriate for this situation, as they will form a trip hazard for people when they enter or exit vehicles. If you can imagine sort of opening your car door and stepping out, it's not exactly like you're stepping onto a curb where the level is even. You're stepping onto a lump that sticks up out of the ground, which is 5 inches high. And I did rather hastily do a search on Friday just to see what the recommendations were for wheel stops where they're placed alongside a vehicle. I couldn't find any reference to it. They're definitely much more suited to 90-degree car parks where there are wheel stops at the front of the car and form no hazard at all. On to visitors by coach. Tour coaches deliver visitors to the Giant's House periodically. This has increased in recent years as the business has become more widely known. It may also be as a result of the many cruise ships visiting since the Christchurch earthquakes. We understand that future cruise ship visits to Akaroa will be much reduced as these will now visit the new terminal in Littleton. This may, however, have the effect of increasing coach tour visits to Akaroa and the Giant's House, as many of these tourists leave the ship to board coach tours, and Akaroa is one of the top destinations for these. In the application report, it is proposed that tour coaches will drive up Rue Balgaree, execute a right-hand turn into Rue Cachalot, then reverse back round the corner and up Rue Balgaree, past 3 properties to the business frontage. Presumably these coaches will then leave the site to park elsewhere while their passengers visit the garden, executing the manoeuvre again on their return. It's difficult to imagine that this will not constitute a hazard to other road users. It's also noted that coaches will only park with engine idling for a maximum of 5 minutes when arriving or 5 minutes before leaving the site. This will need to be enforced rigidly. Coach visitors will also congregate at the entrance building on arrival and on leaving, creating a degree of commercial busyness to the locality. For visitors on foot, 43% of visitors walk to the site, according to the applicant's traffic. These would traditionally approach up Rue Balgaree, where they will start on the narrow footpath, and once they reach Watson Street, will walk on the roadway. Akaroa is a particularly walkable town, so many locals also walk along Rue Balgaree for recreation or simply as a way to get around in a small settlement. It's not uncommon for people to walk in groups on the roadway when there are lower traffic volumes, as this is more comfortable than using the narrow footpaths, especially when in a group. This is part of the relaxed approach to enjoying Akaroa's back streets. We are able to stroll peacefully, enjoying the special character of the residential zone. The road here is also part of the circuit with a number of Akaroa country walks up to the Woodhills track, Purple Peak, Misty Peak Reserve, and is also at the end of the Banks Peninsula track. We often see trampers coming down with all their tramping gear and so on when they're starting or finishing those routes. Those arriving by car also become pedestrians, walking on the roadway for the final 20 to 100 metres of the roadway. The application details an extended footpath on the north side of the road up to a pedestrian crossing opposite the east boundary of the entrance building. As this crossing is located east of the entry building, it will get little use as people will migrate across to the south side as soon as or before they're opposite the entry. The pedestrian crossing will at least need signage and painted lines on the road to make it obvious. Otherwise, I would would imagine no one will get that far unless they're coming down the road from above, which very few people are. Near the start of the extended footpath, Balgaree Stream flows almost to the road boundary. There are hazard prediction measures placed here by the City Council, including high-vis hazard netting and a timber barrier, where the stream threatens to undermine the road edge. That's in the picture below in Figure 7. This will need special engineering design to stabilise the vulnerable stream bank, as well as include new safety barriers for it to be a workable and safe solution for pedestrians. As you can see, where the build-out is to be built in that photograph, there's not very much room at all. So it will narrow the road at that point where we're putting a 1.2 to 1.5 metre footpath. I just also note here in that picture there was a significant nia tree. It would be nice to think that these measures, footpaths and so on along here, don't impact on that tree's viability. The sealed road surface is 9 metres in width. If cars are parked on both sides of the road, as can happen, the trafficable road surface is narrowed to approximately 4.5 metres. This will be less when bus or camper vans are parked. This is not sufficient to support the combined mix of vehicles and pedestrian traffic that will occur on the road at that time. Visitors by bicycle. While this hasn't been a significant part of the visitor makeup in the past, it is considered that it will become more so in the future, with electric bikes on around the township. The Appendix 4B Traffic Assessment Peer Review proposes a condition requiring 6 cycle parking spaces at the entrance building. If these were to be required, they should be located within the site. I note that in an earlier plan, the entry building did show cycle parking. That was 1.5 metres by 700 millimetres in area. This is barely large enough for one cycle path. I just mention this because they will take up a reasonable amount of space in the front of the entry building, 3.9 metres by 1.8 metres deep. In conclusion of the traffic there, our observation of traffic on peak weekends when the Giants House is open is of a busy stream of vehicles through late morning and afternoon, looking for a car park, slowing to make parking manoeuvres, doing 3-point turns into driveways, unloading or loading passengers with groups of walkers threading their way through the vehicles. The Yakara hop-on hop-off shuttle bus also does a run up Balgaree, delivering visitors to the Giants House, doing 3-point turns into someone's driveway and heading back to town. This happens several times an hour at busy times or when cruise ships in the harbour. When a tour coach adds to the activity, it will often sit idling for an extended period, presumably to keep air conditioning operating. Diesel fumes become very unpleasant on these occasions. There are also residents coming and going with boat trailers being manoeuvred or passing through, and the odd rural transport heading over to Stony Bay. And there are also kids on scooters. The effect of all this activity is at times a busy roadway similar to what one would expect in a business zone, as well as that expected in a residential zone. The location of the new entrance building and its wide steps and ramp will become a focal point for visitors to gather and mingle at the road edge while arriving or leaving. The traffic to the Giants House businesses already have at least a moderate adverse effect on the residential bank peninsula zone, and the expansion of the business can increase this. The Christchurch District Plan states that non-residential activities that are not compatible with the character of the residential Banks Peninsula zone are controlled in order to mitigate adverse effects on the character of the area. Provisions in the applicant's proposals to mitigate adverse effects on the RBPZ are not adequate for this purpose. Now on to earthworks. Various comments appear in the planning application section 5 alluding to earthworks. It notes in 5.6, the earthworks will alter this natural drainage pattern across the site in a minor way, which in part will enable drainage to be controlled with a stormwater connection capable of managing drainage across the site. As such, the nominal amount of earthwork will not increase the risk of inundation runoff on adjoining properties, nor will it affect the stability of neighbouring sites or alter surface drainage paths to the detriment of adjoining land. Our property has an 18-metre boundary with the lower north-east corner of the new garden. The new garden is on a steep slope above us, and there is a 1 metre high stop netting fence along this boundary. We are concerned that on such a steep side, and where the works can be simply described as gardening and/or art installations, there is the potential for adverse effects of drainage to be overlooked, as they will generally not require building consents. These activities, with the addition of irrigation systems, can impact seriously on stormwater runoff to properties immediately below. In recent rainfall, we have noticed more runoff than we are used to running through our property, possibly from stormwater redirected by ramped paths that have no runoff management in the garden above. I note that an indicative screening and vegetation plan is now included in the application documentation dated May 2023. This illustrates a series of paths linking the entry building to the upper garden steps. These are 1.8 metres wide. To the cafeteria, 1.4 metres in width, as well as pathways that extend in circuit at the eastern part of the new garden, 750 millimetres in width. I note that the paths shown at 750 millimetres in width, while possibly being indicative, will not be wide enough for people in wheelchairs. They'll need to be at least 1.2 metres wide if it's the applicant's intention that such visitors will have access to all the new garden. As an aside, it's interesting to note that much has been made of the difficulty that visitors have in negotiating the current access to the garden, and so the need for the new entrance. Yes, existing garden at Linton features steep and narrow steps, linking terraces, small courtyards and lookout vantage points. These areas will still not be accessible to people with disabilities. The new access will only serve to give people with disabilities access to parts of the new garden and cafe, and then lower lawns and spaces around the main house. The new paths, as shown, constitute in the order of 280 square metres of presumably hard surface area. This is the equivalent to the roof area of 2.5 medium-sized houses. Not shown are any structures such as mosaic artwork that will add to this hard surface area. These items will all concentrate stormwater runoff and need to have adequate drainage management, rather than stormwater being allowed to simply spill onto the slope. This aspect of the proposed business needs to be well planned and should meet council approvals to avoid adverse effects on neighbouring residential properties, rather than be lightly excused by the artist's spontaneous modus operandi. All hard surfacing and drainage design should be included in any building consent application. Now, my final, I go on to fencing, and I mentioned this really only as Ms. Martin has referred to my submission in her notes. We were asked by the applicants whether we wanted a fence on our shared boundary early in the process, at the same time as they approached other neighbours. We had always been comfortable that planting in our property, along with new plantings in the Giant's house, would provide privacy. We had also thought a broadleaf hedge was to be planted along the boundary in the application site, as has happened along their eastern boundary. In a letter from Ms. Martin that we got in September 2018, she said, we intend to plant a green belt around the boundaries with attractive planting within. And some reason, and I'm not sure whether someone said it to me or whether I made it up, I assumed that the broadleaf hedge would be along our boundary as well. And I thought if we've got a broadleaf hedge over the fence there, that's enough for me to give us privacy. We may have misunderstood that suggestion. When no hedge was planted, we had further neighbourly discussions and that a fence would be built. Various delays over this and possible misunderstandings with the contract meant that it didn't happen. The resource consent application process was extended with no sign of development actually happening. So there was no real concern and the status quo remained. This was over a period of around 3 years. I became concerned in early 2022 when I noticed that the applicant had built their ground overlap with soil and weed material about 600 millimetres against the fence on our back boundary. This is over a length of approximately 6 metres. I discussed this with Ms. Martin and suggested they needed to build a retaining wall here if they wanted to raise the ground level. In a moment of weakness, I guess I was persuaded that this was not necessary and agreed to keep an eye on it. When the resource consent application documents were finally notified a few months later in 2022, I raised this anomaly in my submission. Shortly afterwards, I received an email from Ms. Martin, and she then had the offending spoil cleared off the fence. It would be our preference now, and I made this comment to her at the time, that we should have a 1.8 metre high timber fence along the back boundary with 300 millimetre high retaining boards at the base. As I could see that we were going to get the soil drifting down the hill up against the fence if we didn't do something about it. I asked Ms. Martin to agree to this in an email on the 8th of September last year, in which I offered to arrange a quote. In her reply on the 8th of September 2022, Ms. Martin said, "I'm not looking to do it just at the moment, as I have other commitments going on, maybe further down the track." So, so that was our last communication on that matter. It does suggest that I've said to leave it for now in the submission. I'd also note on the indicative screening and vegetation plan that a broadleaf hedge is now recommended along the eastern boundary of our property. I do wonder how much this plan can be relied on as an accurate indication of what to expect, particularly with the indicative title. I'm just not quite sure what indicative means. Sort of, it's what we're going to do, but we might not. There are also shown on that plan Virginia red robin. It says 11 existing Virginia red robin, which extend most of the way across our back boundary. Those haven't been planted to my knowledge last summer. I do know they are on the rear boundary of Mr. Birch's property, but they are not across the back of our property. A small detail, they can always be planted. Now, in summary, the entry building itself has more than a minor adverse visual impact on the character of the residential Banks Peninsula zone. The building form, detail of windows and doors, or other peripheral embellishments cannot be said to contribute to or reinforce the present residential coherence, character, or amenity of the zone. The commercial nature of the business will be reinforced visually by the presence of signage for the business and the bus stop, cycle stands near the building entrance, the significantly scaled ramp and steps with accompanying handrails. These elements all signal a change in the type of activity occurring in the locality, the consequence of which is a significant visual impact on the character of the residential Banks Peninsula zone. The cafeteria building with extensive use of glazed cladding, high monopitch roof, rounded turrets and bright colour scheme will be a highly visible element on the upper level of the site. These elements promote it as a unique and different structure in the rural Banks Peninsula zone, residential Banks Peninsula zone. The combined impact of the entry building and cafe will be to visually dominate the neighbourhood and the locality, creating a new commercial vibe at the east end of Rue Balgaree, in an area of the residential Banks Peninsula zone, which currently enjoys a semi-rural residential character. Traffic proposals in the carriageway of Rue Balgaree will introduce new built elements to the streetscape. A simple, uncomplicated roadway will begin to gather urban clutter of signage, wheel stops, pedestrian crossings, etc. These elements replace existing green elements, so changing the balance that gives this locality its semi-rural quality. Subtle changes, but there is no doubt that they will alter the existing character and amenity that is currently enjoyed by residents and visitors. The buzz of business activity itself created on Rue Balgaree road frontage, with visitors spilling onto the Berman roadway and increased traffic generated, will have a more than minor adverse effect. The traffic to the Giants House business is already having at least a moderate adverse effect on the residential bank peninsula zone, and the expansion of the business can only increase this adverse impact. Proposals to mitigate the traffic impacts of the business will significantly change the character and amenity of the neighbourhood. The potential for increased traffic generation, lack of any on-site parking combined with other residential and visitor traffic is too great for the size of the carriageway. The provisions in the applicant's proposals to mitigate adverse effects will cause frustration and difficulty for residents and visitors by the loss of existing parking on the roadside. We believe that too much activity is being imposed on a space that was never meant to accommodate it to assist the tourism business expand its operation. The proposals to extend the garden at Linton undermines the potential for residential development consistent with the zone description. There is no drainage planning for the new garden to ensure it has no adverse impact on properties below. We request that, for the above reasons, that Christchurch City Council decline the land use consent on this site for the construction of a cafe and entry building. Thank you.
Thank you, Mr. Knight. I just do just a couple of questions that was very helpful. In terms of the existing operation, and we heard this morning that the way the existing consent is framed means that there's no limits on visitor numbers, and there's some uncertainty as to.
There's no limits on
visitor numbers.
Yes.
So if this consent is refused, then the existing level of activity will be enabled to continue under that existing consent because it's not being withdrawn. Do you see any advantages in this new consent in that it puts conditions on to provide more certainty as to what can happen?
There must be an advantage if there is a limit to the number of visitors to that particular aspect of it. I hate me to say any more than that.
No, it's okay. Presumably you've been on the site or on your property when it's been really busy and when it's been really quiet.
And indeed, we've experienced the extremes of
both extremes,
very, very quiet times and very busy times.
And you would have been there presumably during the busy cruise ship period that everyone has been.
We were.
And have you? Yeah. So that was remarkably busy, as I understand.
Yes, it should be the shuttle that's coming up the Neighbours Drive 3 times an hour, and coaches, and yes, it's certainly very, very busy in those times.
Have you seen it as busy as that since the cruise ship stopped coming?
I can only think to last summer. Spending time there, and I mean there were occasions when we don't have on-site parking. The 2 houses which I think were old state advances or state houses actually way back, and they didn't provide for garaging or off-site on-site parking at all. So we had to park on the road, but so there were many occasions when we would turn up and we would just park up the road somewhere, and when the cars went away, we'd come and park at ours. That does happen on numerous occasions. But your question, I think probably in those times when the cruise ships were coming and there were all of those shuttle buses coming up and down the street, the man in his vintage car going up and tooting his horn at everyone, thinking everyone loves it, with tourists in the back, and then there's the guys with the motorbike and several passengers in the back. That I imagine they're all going to the Giants house, but I don't believe it's reached that sort of busyness since then. But certainly during the summer, there would be days when there would be camper vans and groups of tourists, their car doors slamming and groups getting out and strolling back down the street and in and out. And it's interesting sometimes when Josie was talking about how long some people stay there. We sort of see some people pull up and stroll down to the Giant's house, and 50 minutes later they'd be strolling back again. I think, what was that all about? How can you enjoy a garden in 15 minutes? But and then, of course, the others who would be there for quite some time. So I think it did reach a very busy phase then, and perhaps hasn't been to the same busyness. But I just can't understand how such development is going to take place without having to generate some sort of increase to make it viable. There must be some intent there. It isn't sort of out plain sight.
So looking at the landscape plan, if I'm right, you live on sort of the side.
That's us down the bottom there.
Yep. Yeah. Oh, just right down the bottom there.
That's us.
Yep. Yeah. You mentioned the perspective of it showed the entrance building with the cafe building in behind, and it's between it's your figure 4.
Yeah.
The cross section that Mr. Compton shows this morning showed some planting in between the two buildings. Do you think that would assist in softening any views from the street?
Undoubtedly, anything that screens the cafe building from below is going to break up that dominant curved forms and glazing that we see there. To what extent?
Yeah, needs to be seen.
Happens yet.
Yeah. I think you've covered the points I was going to ask you about. Thank you. It's been really helpful. Good to have the detailed perspective of someone who lives in the area. So thank you very much, and thank you for sitting so patiently this morning waiting for everything.
Thank you.
Right, that takes us to 3. Might be a good time to stop for just a 10-minute break, and then I understand Mr. De Hamill and Mr. Morrissey, are you both arrived? Both here. Okay. Well, if you're happy to wait till about say 3:15, we'll have a quick break, and then we'll carry on with you two. Perfect. Okay. Thanks so much, everybody.
but he's on it. Can you walk to the height and the maximum to screen top left corner? All right.
All right, welcome back, everyone. We have on the list for this afternoon, Mr. Hamill and Mr. Keir Morrissey. Who would like to go first?
Hi everyone, good afternoon. I'm Michael Hamill. For 35, 36 years, I've been editing and publishing the Akaroa Mail newspaper. As it happens, I don't actually live in Akaroa, but my connection with the Giants House goes back quite a long way. But I remember slightly vaguely, in a muddled way that small boys' memories go, of being about 7 or 8 and raiding plums from the garden. And the way that small boys do when they're on holiday, from a rather run-down large house behind Akaroa. I next came across the Giants House in about 1986, when one of my correspondents to the newspaper, Lynn Alexander, rented the place, and it was a bit of a tumble-down mess. I supplied her, I'd had a photographic studio before, I supplied her with all my old studio curtains in order to provide at least some insulation and protection from the draft in the one room that she was managing to live in. And then a few years later, Josie bought it, and lo and behold, it suddenly came together. And then she started building her sculptures, and they started getting attention. Another thing fortunately, probably I don't remember very much visiting the Tiger Barn Gardens before they were demolished, which had large-scale mosaic sculptures. I think I was young enough at the time that I visited not to realise that they were all erotic scenes. And whereas Josie's are actually much more fun. Anyway, over the years, I've been up and visited the place on a number of occasions and noticed that it has become one of the top destinations for somebody planning a visit to New Zealand if they have any interest in gardening. And gardening is certainly one of the major interests in New Zealand. Also one of the top destinations if you're interested in sculpture and sculptural installations and artwork generally. Between when I first saw it when I was young and when Josie took it on, the building was noted as a heritage listing, both by Heritage New Zealand and by the district plan. A lot of what we're facing today, I think, in the questions over Josie's permissions, goes back, in fact, I think, to the decisions that were made by councils probably in the 1950s, possibly 1960s, when subdivision of the garden was allowed, which meant that no longer has it the frontage onto Rue Bulgaria itself, that houses have been built around. It was then listed as a heritage item with no particular thought by the council about how it might be preserved. There have been a number of places on the peninsula where that question wasn't asked, including what's the name of the place at Menzies Bay, can't remember, but and the youth hostel at Pigeon Bay and a number of others around, or even in current talking the Jeannie's Cottage in Akaroa, where consequences of heritage listing are starting to become apparent 30, 40, 50 years after they were first listed. And those consequences include, for example, those that are privately owned, include the need to maintain and look after the building, not just for your own well-being or your own investment, but also as a public amenity. And in my view, the public amenity value of looking after a heritage item means that you must expect that there will be effects of it being listed as a heritage item. There must be expect to be effects on the community around. There must expect to be effects on the council's budget. In fact, Banks Peninsula Council, Akaroa County Council, and Christchurch City Council haven't allowed the budget for the maintenance of those heritage values of buildings that they have listed. In some parts of the country, quite considerable subsidies or rate remissions and things are made towards the cost of maintaining heritage items for the benefit of the community. In Christchurch, and in this case, there are small grants and loans available to assist with painting and things. but the cost of maintaining a heritage building is substantial. My wife and I are the owners of a Category 2 house in Kaiapoi. And it is expensive to paint, it is expensive to look after. You can't easily let it because it doesn't comply with the healthy home standards. There are very few options available other than, as many people do, operating as a bed and breakfast, which happens, or that sort of thing, and a number of things like the Wilderness Akara are operated that way. And in the case of Josie, she has applied her skills to gardening and applied her skills to sculpture. And when she's getting a bill of probably close to 100,000 every time she wants it painted, and probably a bill of 50,000 every time a sheet of iron comes loose on the roof, the scaffolding required. These are costs that are not met for the public amenity value of the thing. At the same time, when the property was built, I'm pretty certain those front two sections in front were part of the garden. If that had remained the case, all that would have been required would have been a boundary adjustment. You can't have proposed structures as a garden shed or something similar, or an associated use with a heritage building, rather as associated building uses with Kate Shepherd House in Christchurch and things. But as it is, because it's a separate title and it hasn't been in continuous ownership, it is not on the district plan as part of the same site, which it would have been otherwise, and therefore has to be considered separately. She's being discriminated against again, even though she is attempting to look after the heritage structure and the well-being for the public good. The other thing that I was going to mention, I mentioned in my submission, is that if you have a building or a structure or a site which is heritage listed, you must expect that people want to see it and provide access for it. There's a fuss in Akaroa at the moment, for example, about the poor access to the Bretton Martin Memorial. That's been owned by the council for donkey's years and managed by the council, and yet there still isn't a decent path up to it. Here we've got a person who has one of the heritage items. We're wanting to make sure that there is public access and providing better public access. Neighbours around must expect some visitor activity and the access to occur, and that there must be some disruption. When they bought their house, or when they were presumably given consent to the subdivision of those front sections, or when the heritage listing was made, there was an opportunity for the neighbours at that stage to make long-term suggestions about what amount of disruption they were prepared to put up with, and they might have been able to put in a submission saying this shouldn't be listed because it's going to disrupt our community. But they didn't, as far as I know, and the listing was granted in the more recent resource consent that Josie is currently operating under granted. But so it's a long historical thing, and it's actually now trying to rectify the historical mistakes that were made in granting consents without consideration for access, without consideration for the financial cost of burden of running a very large heritage building. And of course, the council is trying to promote tourism and the visitor industry and everything else. And here we have a prime example of what can be done and what it's trying to do. The other thing, sort of little note that I made on the way past, is that I'm not sure whether this is possible, if there had been a boundary adjustment done before this application came in, to bring the boundary of the title that the Giant's House is on down to Ruvalgiri, whether that extended boundary would have been part of the site of Linton, or whether it was not included. Now, I'm not sure how some district plans, when the boundary of the site is the same as the legal boundary of the title on which it sits. In other district plans, the boundary of the site is a line across somewhere on the title of the site. And I'm not quite sure, but I strongly suspect that if that lower section had been an L-shaped site, the whole thing would be listed as the site of Linton. And therefore, this would have been a relatively minor bureaucratic thing to say, yes, she's allowed a garden shed, and yes, it's safer to the structure of the property to have a cafe done at the bottom away so that if there's a fire risk in a cafe, it doesn't affect the main structure, and similar sorts of things, and to make it easier access for people to come and see that heritage thing. And overall, there must be some allowance in the district plan and in judgments on it for the heritage listing effects of the heritage listing must be heritage listing must reflect there must be somehow an underlying value to the community, which means that any effects are judged at a different level as to whether they're minor or major or need consideration. There's a sort of underlying value to the community which lifts the bar for disruptive effects across the community elsewhere, for neighbours being upset and similar sorts of things because of that previous listing and because of the value to the community of maintaining the heritage item. Happy to answer any questions.
Thank you. No, I think you've highlighted what's been a long running tension, I think, including circles around heritage buildings and wanting to retain them, but being no access to funding. And so
as a side on that, perhaps I could add that in some district plans, there is room, as there is for Marai and some other objects, for rating relief, for example, to be given to owners of heritage buildings as a method under the district plan for ensuring the maintenance of heritage buildings. I don't think Christchurch has that because there is a public value in that heritage item. There's a public value in that land, that listed tree, or whatever it is, that effectively the owner of something like the Giant's House is paying through their rates for the public value of amenity value of the other heritage items that are protected around the place, both public and private ownership, and they're paying through their own pocket for the maintenance of that particular item. They're paying twice for the same public benefit.
So, I think that submission is a very, very helpful perspective. I think I don't have any questions, but I understand the point you're making. That if you own a heritage building that is publicly listed, then you need to find a way to offset the costs of maintaining it, and B, people are going to want to see it, and it's going to impose some level of effect. Yes.
That there is going to be disruption because of this. And the time to address that is at the time of the listing or at the time of the subdivision, not later on.
I understand.
And I think one has to assume that it was addressed at the time of the subdivision or at the time of the listing. Before my time, probably.
No, that's very helpful. Thank you very much.
Thank you. Thank you, Manish. Have I got on the storms?
Right. Mr. Kiloji.
I'm not a speech maker. I thank the committee for giving me the chance to voice my strong support for Josie Martin and her desire to extend her International Garden of Significance and complete the vision she has to make the Giant's Garden a globally important work of art. My remarks are aimed to put this hearing into the context of the wider themes that surround Josie's application for consent and to help the committee to include the bigger picture in its deliberations, so that the minutiae of rules and precedentism don't overshadow the very real prospect of your facilitating a dazzling, important and lasting addition to early 21st century art in Canterbury. All contributions to national life and culture are important, from sport, both amateur and professional, through science and academia, good works and volunteering, to business and farming, and the love and protection of our natural wonders. Every positive action has a call on society's encouragement. Yet among all the contributions we collectively celebrate, the arts are quite often forced to play the poor relation. Needy and often eccentric visionaries, artists are easy to deride. Yet hawking a personal view on life has so often proved to be the prophet of future thinking. In this instance, you are the representatives of society. So it's my hope that you'll start from the proposition that to encourage an acclaimed artist like Josie Martin to continue to reach out to society and achieve her vision is your overriding aim. At this point, Josie's partway through her creation, to the delight of the thousands of admiring visitors who've enjoyed what she's achieved so far. But no artist is happy with an incomplete canvas. We must give this fine and proven artist and gardener the space she needs to finish. She's a famous and brilliant sculptor, a colourful and challenging painter, a highly qualified and experienced horticulturalist, and a ceramicist of rare insight and talent. Her work has proved to be a major drawcard in Akaroa's crucial need to attract visitors. That brings me to the business side of Josie's conception. Small business is the cornerstone of commercial life here in New Zealand. Hard-working, dedicated people who have an idea they want to pursue. Small business people create jobs, both for themselves and others, fill our communities with varied and interesting possibilities, provide a focus for specialties of all kind, and generally pepper our society with convenience, colour, enlightenment, and polish. As we know, successful businesses grow. Success breeds success, and so it's been for the Giant's Garden. No small businesswoman who sees a growing number of customers wants to disappoint them by being unable to expand in order to include them or provide something new for them to experience. And that's what Josie is asking for you to approve, not only the chance to complete her vision, but to make her business more accessible and available to those who by word of mouth have heard that there's a sculpture garden well worth visiting. Jobs come with expansion. The citizens of Akaroa survive in Maine on the tourist trade, whether local or international. A tourist town must have attractions, and Akaroa provides plenty, from harbour wildlife cruises to top quality history museum, stargazing and farm tours, magnificent nature walks and bright bike rides, and Josie's ever-changing garden. I'm pretty certain that every small business venture in Akaroa would be 100% behind Josie's plans, because they understand that all businesses benefit from visitors attracted by another. Just ask the proprietors of the fish and chip shop or the classiest restaurant in Akaroa. Josie Martin provides a unique quality attraction that rewards a second look or a third. But it needs better access and convenience to support its growing reputation and widen its audience. And what of the legacy Josie will leave Akaroa and New Zealand? Many of us will have visited a famous garden as part of our OE in Britain, Europe, China, or Japan. Indeed, they're the main focus of many of the garden tour OEs New Zealanders like. Rarely in the centre of the business district, some of these historic gardens are the only visitor focus on the edge of a tiny village or town, whose ancient streets are packed with the cars of visitors who nowadays keep the hamlets alive. In almost every case, their creator is long gone, but the personal vision they had and their expert skills in building it resonate strongly with those of us who succeed them. So it will be with the Giant's Garden. Allowing Josie to complete her brilliant project will benefit not only those of us living who appreciate its excellence and inventiveness, but those yet to come. Enabled by a future-focused council, a completed project will live on to reflect our time and ideas to posterity. Of course, you have the unenviable task to balance pluses and minuses, and I wish you well in your deliberations. You're getting on the end of a long day. But I hope my contribution has reminded you of the immense positives to encouraging a successful artist with a large following who wants to work hard to achieve a huge and happy installation that will live long after our own age. So supporters of Josie Martin ask you to give her a break to a hard-working and highly successful Canterbury artist. Your friends, as well as your children and grandchildren, will thank you for it.
Thank you very much. It's very good that somebody's not a speech maker.
I know. I was thinking.
No, I don't have any questions. I don't think I could elicit anything further from you. But good. Are you happy to leave a copy of that for the record? Or
Yes. Thanks very much.
So give us a copy of the hearing information. So no, thank you very much. That was
good. Thanks for the chance.
Thank you.
My suggestion was interesting.
All right. takes us to the end of the submitters that we had who wanted to speak today. I don't know whether there's anyone else in the room who wants to go today or whether you're happy to come back tomorrow. Tomorrow's fine. Okay, in that case, we may as well adjourn for today until 9:30 tomorrow. We'll kick off tomorrow, 9:30 tomorrow with 9:30 tomorrow morning. Yep. Scheduled to go through until 1 with a number of submitters, and again through to 2:30. So, going by today's progress, we should be making pretty good time, I would think. So, okay, thank you. All right, thanks very much.